Good morning. I am the Registrar Clerk for this hearing. Acting Deputy Chief Justice and the Justices of the Constitutional Court, all counsel are online. I call the matter of Chairperson of the Council of the University of South Africa and Afriforum for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Thank you, Ms. Sipapa.
I apologize, Acting Deputy Chief Justice. I was going to put myself on record. I appear for the applicant for leave to appeal together with my learned friend, Mr. Wesley.
Thank you, Mr. Chairperson.
May it please you, Acting Deputy Chief Justice, Justices of the Court, I appear for the respondent together with my learned friend, Mr. D'Oliveira.
Thank you, Mr. Cockrell. Mr. Chairperson.
Thank you, Acting Deputy Chief Justice. Justices, in this case, Afriforum invokes Section 29(2) of the Constitution in an attempt to preserve historical privilege bequeathed by apartheid. Afriforum wants UNISA to subsidize Afrikaans home language learners at the expense of all other learners. On its own version, these Afrikaans home language learners are less than 10% of the student population, and more than 2/3 of them are white. Yet it wants UNISA to take resources away from its African language speaking students who carry the historical burdens of the apartheid legacy, so that the university can continue to subsidize this group of primarily white Afrikaans speaking beneficiaries of apartheid privilege. The basic premise of the Afriforum case is at odds with fundamental principles of equality and transformation that underpin our Constitution. Now, in order to advance its case, Afriforum has put forward a narrative in terms of which Afrikaans-speaking students were the victims of an ill-considered and irrational change in language policy that was sprung on them without notice in a knee-jerk response of the UNISA authorities to placate a populist Afrikaans must fall lobby within UNISA students. This narrative is simply false. Nothing was sprung on anyone, and there was no last-minute capitulation to an Afrikaans must fall lobby. Instead, there was a lengthy, considered response to an untenable situation at UNISA, where the arrangements built on the legacy of apartheid meant that white Afrikaans students were being subsidized at the expense of all other UNISA students. That response required the amendment of the UNISA language policy. And the process of amending the language policy involved more than 2 years with cycles of consultation, consideration, and revision before the new policy was finally adopted. But throughout all of those consultations and revisions, 2 principles were absolutely clear. The first was that the proposed new policy would make English the only language of teaching and learning at UNISA. So Afrikaans would lose its status as a language of teaching and learning, status that it had under the old policy. And the second is that in place of the old policy where Afrikaans had a privileged status, a principle would be put in place where learner support would be offered in all 11 official languages to all students. We will show that the language policy is a rational policy and one that's wholly compatible with Section 29(2) of the Constitution, which cannot require a university to subsidize beneficiaries of apartheid at the expense of the victims of apartheid. We will show also that the SCA judgment that set aside the adoption of the new language policy is legally wrong because it misapplied the objective test of reasonable practicability in Section 29(2) of the Constitution, both on the facts and on the law. Now, in these oral submissions, I propose to follow a slightly different structure from our written submissions. I'll start with the facts. The facts relating to the context, relating to the changes in the language policy and the context in which those changes were made and the process by which those changes were made. Then I'll address the law relating to Section 29(2) and show, contrary to the judgment of the Supreme Court of Appeal, the Afriforum complaint does not make out a case under Section 29(2). I'll respond to the procedural rationality argument that is raised by Afriforum in its heads, although we have not addressed it in our heads because it did not form the basis of the SCA judgment. And finally, I'll address the flaws of the SCA judgment in relation to remedy. To start then with the facts, and Acting Deputy Chief Justice, at this point, I'm through my introduction, so if any of the justices wants to call me up on any of my submissions, I no longer require the 10-minute protection.
Thank you.
We address I beg your pardon, Justices, my file touched the mouse and muted me. We address the old and new language policies from page 9 of our heads. And we start with the 2010 language policy, which contains the material provisions which Afriforum seeks to resurrect. That policy operated in a context in which historically English and Afrikaans had been the two privileged languages at UNISA, and all teaching and learning took place in English and Afrikaans. That context was a direct product of the pre-1994 privileged status of English and Afrikaans. They were the pre-1994 official languages, and why they were the pre-1994 official languages is that they were the languages that white people spoke. So what the 2010 language did was it served to entrench the historically privileged status of English and Afrikaans. And we deal with the provisions of the 2010 language policy and its appeal to functional multilingualism. But as we point out on page 10 in paragraph 14.2, that off a base of a system which provides that courses are taught only in English and Afrikaans, the stated commitment to multilingualism meant that Afrikaans continued to be entrenched despite dramatically failing demand.
Chaskelson, can I just interrupt you? You said you don't need protection. You say only white people speak Afrikaans.
No, I didn't say only white. On the facts before, on UNISA, on Afriforum's own facts, 2/3 of the Afrikaans-speaking students at UNISA are white-speaking, are white Afrikaans-speaking students.
Yes. You also refer in your heads to Afrikaans as a non-indigenous language. It's indigenous to which country then?
Well, it derives from Dutch.
Yes, but is it not indigenous to South Africa? It's got variants from the Khoisan, who were first settlers here, first residents here. It's got variants from the Malay slaves who came here. There are many words in Afrikaans that come from the Malay language, like bladjang, which is chutney, and pisang, which is banana.
No, I'm aware of that, and in fact, Justice Majid, I'm told that the first written Afrikaans was in fact written in Arabic script, because
Correct.
it was first written
Yes,
by,
it was written
Malays.
Yes, it was written in a madrasa by a Malay slave in Cape Town.
Indeed.
So I think we just need to get the history correct. I think there's a substantial number of Afrikaans speakers who are not white, and secondly, it is, I think, an indigenous language. If one needs to get the history right, I just wanted to clarify that with you.
No, I don't dispute for a minute that there are substantial numbers of Afrikaans speakers who are not white. But on the facts before this court, even on Afriforum's own version, 2/3 of the Afrikaans speakers, more than 2/3 of the Afrikaans speakers at UNISA are white Afrikaans speakers. And
Yes.
so the primary beneficiaries of a policy that protects Afrikaans are white. And that is
Yes,
mere,
yeah, while we're busy with that, having said that, it is so that Afrikaans obtained a privileged position, which clearly is based on historical reasons, and it has received the attention of this court. And what I wanted to ask you right at the outset is, the SCA laid much emphasis on the fact that there are crucial material distinctions between the factual scenario in this case, because UNISA is a distance learning institution, and between a Free State University case and the Gelyke case, which concerns Stellenbosch, which are residential universities. What do you make of that distinction? Is that distinction material in this case? Because the SCA laid much emphasis on that, and so does Afriforum here.
Justice Majid, we are dealing with a different situation because we're dealing with a distance learning situation, but issues of resources still remain crucially relevant. And in an ideal world, UNISA would be resourced sufficiently by central government to be able relatively quickly to extend language of learning to all 11 official languages. But in a world where UNISA has a constrained budget, where it has to carry the burden of its own language policy choices, and where it simply doesn't have the resources in the short term, at any rate, to extend language of learning to all indigenous languages, or indeed to any indigenous languages other than possibly Afrikaans, if it is going to be characterized as an indigenous language. Then the question of subsidizing Afrikaans-speaking learners at the expense of non-Afrikaans-speaking learners becomes a very pressing issue. And the distinction between a correspondence university or distance learning university and a residential university doesn't do away with that question. Merely means that it has to be posed in slightly different terms.
Yes, thank you, Mr. Chaskar.
The terms of the new policy are set out in our heads, or the crucial terms from pages 10 to 11. And what I do want to emphasize in pages 10 to 11 is that Afriforum presents this case as a case just about changing the status of Afrikaans at the university so it was no longer a language of teaching and learning. But in fact, the material changes to the language policy went much further than that and had a much broader effect than only on Afrikaans students, because what the new language policy did is essentially said English will be the language of teaching and learning in all courses at undergraduate level. But what we will now introduce is very detailed and dedicated provisions for language support to all students whose first language is not English. That was the model of the new language policy. And so for most African language speaking learners at UNISA, the new policy was one which for the very first time offered them dedicated language support to assist them to overcome the difficulties of studying in a second language. There is another fact that I want to emphasize in relation to the new language policy, which is it was tied to an implementation plan that was designed to protect the rights of existing Afrikaans-speaking students. So it was phased in. The implementation plan provided that it would be phased in a manner that ensured that any existing Afrikaans language learner in first or second year of their degree, who was on a course trajectory to do Afrikaans language modules in subsequent years of study, would be able to complete their degrees before those Afrikaans language modules were phased out. So while first year Afrikaans language modules were to be phased out in 2017, and in fact were phased out in 2017, second year Afrikaans language modules were only to be discontinued in 2018, and third year Afrikaans language modules were only to be discontinued in 2019. So if you were a first year student who had come to UNISA to study in Afrikaans in 2016, in 2016, you could do your second year module in Afrikaans in 2017 and your third year module in 2018. It was only from 2019 the third year modules would be phased out. And that, the reference for that, although it is common cause, is volume 1, page 221, paragraph 12.16.6. Now, at page 12 of the heads, we set out the facts against which the decision needs to be assessed for the purposes of section 29.2. And I want to amplify those facts because they are the subject of some controversy from our opponents. The first fact is that the percentage of UNISA students with Afrikaans as a home language is small. It was 8.6% in 2015 and 8.7% in 2016. I want to emphasize that on the applicants, on the statistics put up by the applicants themselves from the UNISA system, we're talking about, in 2016, 23,785 Afrikaans students. And the reference to that is Annexure AB1 at page 569. That's Professor Potgieter's annexure that he drew from the UNISA system. If one looks at Annexure AB1, and unfortunately, it's an annexure that sort of is in two different parts at two different places in the record because the applicants put it up first without one of its pages and then had to file a supplementary to add the second page. So it's at page 569 and at page 565. We see that this number of 23,785 Afrikaans home language speakers is less than half the number of English speakers, less than half the number of isiZulu speakers, and less also than the number of Sepedi speakers, who are classified as North Sotho speakers at page 565, not at page 569. The other fact about the Afrikaans home language speakers is that more than 2/3 of them on the applicants version, sorry, on the Afriforum version are white. And that appears at page 38, paragraph 201. If one looks at the numbers there. No, sorry, I've got the wrong statistic. I've got the wrong figure there. My note is incorrect. I'm going to ask Mr. Wesley to find where paragraph 201 is.
Sorry, Mr. Chairperson, while we're on the record, can I just take you back to the previous one, the statistics of the Professor Potgieter one, AB1. Did you say page 565 and 569 of the record?
Indeed, Justice Majid, it's 56. So the record has sort of awkward numbering. The bold numbering is the legacy of the Supreme Court of Appeal record.
Yes.
But the handwritten numbering is the pagination of this court's record, or the pagination for this court. And my references are to the handwritten page numbers. So sometimes the bold ones are easier to follow. If I can give you the
give me the ones in bold, please, because that's the mistake I made. The ones in bold for Professor Potgieter, annexure AB1, please.
So 569, one half of it is in bold 559, where one sees the 23,765 Afrikaans students as opposed to 61,001 English students, and I think it is 59,504 isiZulu speaking students.
Okay, I've got it now, thank you.
And then the second half of that annexure is 4 pages up at bold 555.
Yes, thank you.
The reference that I needed for page 201, sorry, is for paragraph 201, where we see that more than 2/3 of the Afrikaans students are white, is page 382. 382, again handwritten. There is another important fact to bear in mind, which is on the Afriforum's own version. Almost half of the Afrikaans home language learners don't choose to study in Afrikaans. They choose rather to study in English. And that flows from the report of Mrs. Borman's survey, which appears at volume 2, page 376, at paragraph 196.3. And I want to emphasize, I'm not for a minute suggesting that Mrs. Borman's survey is an accurate, Professor Borman's survey is an accurate, scientifically sound survey, because she sent out 32,000 questionnaires and got back 2,749 on a self-selecting basis. So this is not a random sampling process. But even with those difficulties, and in the context of a process which was probably calculated to serve the purposes of the person sending the surveys out in a way more than a true random sample would have done, she received responses that said that of the people who completed her questionnaires, only 50.7% of Afrikaans home language speakers indicated that they elected to study in Afrikaans. So with all the difficulties of her survey, she still could only come up with an answer that 50.7% of Afrikaans home language speakers wanted to study in Afrikaans. So that is reflected in the number of modules offered at UNISA that were taken up in Afrikaans. The 20.2, we point out that the percentage of UNISA students who chose to enroll for at least one module in Afrikaans, at least one, is considerably lower than the home language percentage. It was 5.3% in 2015, and it declined to 5.1% in 2016. And the percentage of modules that were taken in Afrikaans, so the first statistic was how many students, what percentage of students took Afrikaans modules. The second was, if one looks at all of the modules offered, what percentage of them were taken in Afrikaans. The statistic at paragraph 20.3 is 2% in 2015, 1% in 2016. Now, there's some controversy over this figure, and Afriforum says, no, the figures are wrong. We submit that on the basis of Plascon-Evans, the figure in the UNISA affidavits has to prevail. But even if we were to take Afriforum's own figures, they show remarkably low demand for Afrikaans modules. So Afriforum's own figures are to be found at volume 3, pages 377 to 378, paragraph 198.1. On Afriforum's version, there were 98,816 modules taken in Afrikaans out of a total of 1,881,267. 5.15% is Afriforum's figure. It's higher, but it is still very low. And if one goes a little lower down into the College of Economics and Management Sciences, which Afriforum cites at page 378, paragraph 198.3, it's only 3.6% of those modules that were taken in Afrikaans. And even in the modules with the most Afrikaans students that Afriforum can point to, the number rose only to 5.2%. That appears from 198.4 on page 378. Now, under the 2010 language policy, it was permissible to discontinue Afrikaans language modules only in accordance with guidelines adopted by the Senate Language Committee. And what you had to show as a department to stop offering a module in Afrikaans was that for 6 consecutive semesters over the 3 preceding years, the module in question had never attracted 15 learners who wanted to take the module in Afrikaans. And even after a decision to discontinue the modules in Afrikaans had been taken, a learner had the right to submit assignments and examination papers in Afrikaans and to be furnished with an Afrikaans examination paper on demand. So UNISA had to have the staff facilities to be able to assess assignments and exams in Afrikaans. Now, because of the low demand for Afrikaans, for several years, the Senate Language Committee's agenda was inundated with individual requests from academic departments to offer modules in English only, in line with the guidelines. Now, when that allegation was made on the papers, it was not disputed. It was made at page 485 to 486, paragraph 91, and the response to that in the reply at page 559-68 did not take issue with that proposition. In Afriforum's heads, there's now an attempt to make out an argument based on whatever parts of the Senate Language Committee made it into the Rule 53 record that that isn't the case. Well, with respect, that argument is untenable. It's impermissible, firstly, because it's not an argument that was raised on the papers where the allegation wasn't disputed. Secondly, not all of the Senate Language Committee proceedings are in the Rule 53 record. The only ones that are in the Rule 53 record are those relevant to the decision to change the language policy. And finally, what is clear from the Rule 53 record is that the greatest number of discontinuations because modules had, demand for modules in Afrikaans had fallen below 15 students for more than 3 years, was an issue that served not before the Senate Language Committee, but before the Senate Teaching and Learning Committee, because the Senate Language Committee wasn't going to meet for a long time. That appears from the minutes of the Senate Language Committee of 3 April 2014. It's at volume 4, page 653, which was 643 in the bold numbers. And under item 5.3 of those minutes of 3 April 2014, the following is recorded. On 19 February 2014, it was resolved that Mr. Blignaut should complete a list of all the modules with fewer than 15 Afrikaans-speaking students. The list should serve its Senate to request the modules need not have an Afrikaans examination paper, as there'd been no material available on the web. It was noticed that the list of all the modules with fewer than 15 Afrikaans-speaking students had not yet been finalized, as Mr. Blignaut was still awaiting comments. Resolution. The Senate Language Committee resolved that Mr. Blignaut should submit the list of all the modules with fewer than 15 Afrikaans-speaking students to the Senate Teaching and Learning Committee, since the meeting of the Senate Language Committee would take place only in September 2014. So that comprehensive list of all of the modules without demand beyond 15 didn't serve before the Senate Language Committee. It went to the Teaching and Learning Committee, and from there, one imagines, to Senate itself. What we do refer to in our heads is, merely for illustrative purposes, is some of the instances of these applications to discontinue teaching in Afrikaans that do emerge from the Rule 53 record. We refer to them from paragraph 21 onwards. They speak for themselves. I'll maybe mention one or two. On page 15 of the heads, paragraph 21.4, there was a request, we refer to a request to offer operations management MN 2601 only in English. And the statistics showed that the course, this is a request that comes in 2016. The course had been offered in Afrikaans since 2014, with all the resources necessary to facilitate this. More than 9,000 modules were taken in the course over this period. So it's a course with big enrollment. and only 3 of the 9,000 had been requested in Afrikaans. So this course had been provided in Afrikaans in circumstances where over the previous 3 years, only 3 of 9,000 modules had been taken up in Afrikaans. There's another example that I would like to emphasize. It was the application from the Department of Life and Consumer Sciences, which requested permission to provide all 49 life science modules only in English, after none of those modules had attracted 15 takers in Afrikaans over any of the previous 6 semesters. 39 of them had attracted no takers at all in Afrikaans in at least one of those semesters. So they put up all of the statistics. Prima facie, they qualified under the policy, but the Senate Language Committee refused the application because no one from the Department of Life and Consumer Sciences was present in person to motivate it. So that department in 2016 had to continue to devote resources to providing these 49 modules in Afrikaans, despite the absence of any meaningful demand for Afrikaans language learning in the modules. And if the SCA judgment is upheld by this court, UNISA will now have to resurrect Afrikaans learning in all 49 of these modules, despite the fact that there's been no meaningful demand for any such learning since 2014 at least, and possibly from before. I now want to depart from my heads to talk briefly about the process by which the new policy was adopted, because Afriforum in its heads places some emphasis on that process. And the common core starting point of that process, in terms of the introduction of a provision that would make the language of learning and teaching at UNISA only English, was the Consultative Conference in March 2014, 2 years before this decision.
Mr. Chairperson, while you address that, can you keep the following in mind, which I'm interested in your argument? Afriforum says that UNISA didn't take into account considerations and information that was relevant to whether it would be reasonably practical to continue with the 2010 policy. And in its written submissions, if I'm correct, it's paragraph 23, UNISA lists a number of facts that point towards the conclusion that it was not reasonably practical, but UNISA doesn't say that it took those factors into account. It lists the factors to say why it's not reasonably possible, but it seems to me that nowhere in the record does it appear that UNISA actually took those facts into consideration. The second point I'd like you to consider in your address on this aspect is that Afriforum says there were concerns raised by the Senate, and this is particularly in respect of the meeting in October 2015, and I know you have touched on this, that were not addressed by the Senate or the Senate Language Committee. And does UNISA accept that it didn't address some of these concerns? Thank you, Mr. Chairperson.
Just to foreshadow where I will go in response to both of the issues that you put to me. On the first issue, I want to emphasize that I will be addressing legal argument in relation to Section 29.2. And my legal submission is that the Supreme Court of Appeal misconceived the nature of the inquiry under Section 29.2, which is an object of inquiry. It's not a subject of inquiry with reference to what actually served before a decision maker or not. In the same way as one doesn't test the validity of an act of parliament by considering what served before parliament when they took the decision, but rather by looking at the objective facts that either justify a limitation of a fundamental right or don't. Section 29.2 applies in the same way. My submission is that what the Supreme Court of Appeal effectively did is applied a test appropriate to administrative justice in relation to a decision that wasn't about administrative action. And so at the level of law, what did or didn't serve before the Senate Language Committee is strictly speaking irrelevant. If as a matter of objective fact before this court, there is evidence to show that the decision is one that passes muster under Section 29.2 objectively. The fact that any one of those particular pieces of evidence didn't serve before the Senate Language Committee doesn't affect the constitutional validity of the language policy. In much the same way as if this wasn't a decision taken by UNISA, but a decision taken by Parliament, which most Section 29.2 decisions, most Section 29 decisions probably will be. One doesn't look at what Parliament scrutinized. One looks merely at the objective facts and whether this is a rational use of resources in terms of a test of what is and isn't reasonably practicable. So that is essentially the argument in response to your first question. In response to your second question, I'll get there in due course.
Before you move on to the second question, if those sort of factors aren't relevant, what sort of factors are then? What are the quote-unquote objective factors that you refer to?
Evidence before the court on whether this is or isn't a rational use of resources and whether it is or isn't reasonably practicable.
But what informs that? What informs that? That's whatever it is that's before us. Or what exactly is it? What's the nature of it? If the factors that my sister Justice Theron referred to are not relevant, what exactly is it for us that we take into account?
And then I beg your pardon, Justice Madlanga, we're at cross purposes. The factors that Justice Theron put to me about resources and numbers and the like are most definitely relevant. What I submit is not relevant is whether they were specifically considered by particular decision makers within the university at particular times, because this court must make a finding on whether objectively those facts show that it is reasonably practicable to continue privileging Afrikaans at UNISA or not. And that decision is a decision of this court based on the evidence before it, without reference to questions of whether particular facts served before the Senate Language Committee at particular times. So this court has regard to all of the objective facts that go to the question of whether it's reasonably practicable. And it can have regard to those facts, whether or not those are particular facts that were considered by the Senate Language Committee or Council. And at a conceptual level, that's because that decision is not administrative action. If it was administrative action, then one would be focusing on the subjective position of the decision maker and what served before the decision maker, whether the decision maker had regard to relevant considerations. But we know that this court has held that it's not administrative action. So that's the legal conceptual reason for that. But at the level of constitutional purpose, it makes total sense for this court to approach the matter objectively, because what this court is deciding is whether a particular allocation of resources passes constitutional muster or not. And it should do that, having regard to the objective facts. What it shouldn't do, and what the Supreme Court of Appeal judgment did in effect, is to say, we will force on UNISA, or we will prescribe an allocation of resources that privileges historical beneficiaries of apartheid, makes victims of apartheid subsidize them. We'll do that just because the relevant facts were not properly considered by UNISA. Even if all of those relevant facts had been before UNISA, we'd accept that it was an objectively justifiable decision to amend the language policy the way it's been amended. So the court is dealing with a question about allocating resources. It has to approach that question on an objective basis and ensure that the resources get allocated in an objectively rational way consistent with the Constitution. The fact that the decision maker didn't have regard to a particular fact shouldn't force the court to impose a constitutionally non-compliant allocation of the resources and effectively say, well, until the decision maker goes back and looks at these facts itself, we're going to force the resources to be distributed differently.
Please don't forget to go to the second question by my sister.
Yes, no, I will go to the second question.
Thank you.
The second question, there are essentially two responses to the second question. The first is at the level of fact, Afriforum mischaracterizes the nature of the concerns, of the primary concerns expressed at that October 2015 Senate meeting. The primary concerns at the October 2015 Senate meeting were not from the Afrikaans language lobby. They were from the African languages lobby, which said this policy does not go far enough. And if one reads the minutes and one reads the transcript, it's quite clear that the primary concern at that Senate meeting was this doesn't go far enough, and we want to, and the lobbies that wanted to go further haven't properly been consulted. Now, there's nothing on the papers to suggest that the lobbies that wanted a more transformative language policy weren't consulted. And in fact, the fact that Senate, second time out, adopted it in the face of no opposition from the transformation lobby, suggests that people were quite happy with the process between October and March, people other than the Afrikaans language lobby. But the second response is again a conceptual response, which is that if one is dealing with a decision that can be reviewed and set aside only in terms of 29.2 or in terms of procedural irrationality, then questions of process take on a very narrow ambit in relation to validity. 29.2 doesn't deal with process. Questions of reasonable practicability are objective questions independent of process. Rationality has a very narrow procedural element, but the question in relation to rationality is, well, the procedural irrationality argument is one that is very, very tightly constrained. And once I've gone to the facts, I will submit to this court that this case comes nowhere near where one would have to be to set aside a decision on procedural irrationality. But to do that, I need first to get to the facts of the process. So that process starts in March 2014, where there's a consultative conference that UNISA holds. And there is a report on this conference at volume 4, page 670. And now all of the references that I'm going to refer to in relation to the process are not in the heads, because this is an argument that we didn't canvass in the heads. It's really responding to Afriforum's argument. Professor Zawada's presentation to the conference appears at volume 5, pages 966 to 985. And at pages 977 to 979, there are slides where she highlights the hypocrisy of the present language policy, or the old language policy, the 2010 language policy, which proclaimed a commitment to multilingualism, but in fact did nothing of the sort. And it's possibly, if I could take the court to that presentation, because it encapsulates what the real problem was of the language policy. If we go to
again,
page 900.
Sorry, Mr. Chairperson, again, sorry, just to be clear, when you make references to the record, are you referring now to the bold pages or to the handwritten pages?
To the handwritten pages, Justice Majid. When I go to a particular page, I will quote the bold page for your benefit.
You see, my difficulty is that neither the core bundle that I have before me nor the the original record has handwritten pages. It only has the bold. For some other reason, inexplicably, mine do not have handwritten pages. I have the record before me, and unfortunately, I know it's a schlep to have to go back and forth to cross-reference and so on. But I'm in a quandary as far as that is concerned. I only have bold pages. I'm sorry about that. Perhaps your junior can help us with that.
Can I what I will ask is for Mr. Wesley to take. You see, Mr. Wesley doesn't have my notes, so he doesn't know which page I'm going to next. But
see what you can also do. What you can also do is after the hearing. I'll be really grateful if you could do that with the help of Mr. Wesley there. If you could submit a document outlining the cross-referencing, the bold pages and the handwritten pages. Because as I say, I'm trying to follow the record, but I only have bold pages. We could also do that after the hearing. If you could submit that cross-referencing. And then in the notes, I will refer to the handwritten pages and then have regard to the document afterwards that cross-references.
Thank you for indulging us that way, Justice Majid, and I apologize for the for the record.
Thank
you. Obviously, if I take the court to a page, I can then see the bold page, and I will refer you to it at the time. And so, if one can go then to Bundle 5, bold 974, handwritten 977, one sees a slide from Professor Zawada's presentation. And the slide is headed Language Teaching, brackets LOLT, which is Language of Learning and Teaching. And the third bullet point is currently UNISA claims to make all courses available in all 11 official languages. And if one goes over the page to the next slide, there's a slide which really speaks to the hypocrisy of that statement in the language policy. The slide just says "rarely?" ? And the next slide on page 976, bold 979, handwritten, says functional multilingualism is an escape clause. In reality, UNISA has become an English university as more and more courses move to English only by diminishing Afrikaans with no African languages being introduced. And then in response to this situation that Professor Zawada was describing, she made a proposal. And the proposal appears several pages down. It's bold 979, handwritten 982. And the proposal is the proposal that essentially triggers this process, and it embodies the principle that Afriforum objects to. The proposal is that for the purposes of language of learning and teaching, UNISA distinguishes between formal tuition and learner support, explains what formal tuition refers to, what learner support refers to, and the fourth bullet point, formal tuition is in English only, learner support is in all of the other official languages and has to be implemented in a compulsory but phased-in approach with resources provided. So that is the genesis of the new policy, a distinction between language of learning and teaching, which will be English, and learner support, which will be expanded dramatically and will be provided in all 11 official languages. What then happened was on 3 April 2014, the Senate Language Committee proposed an amendment to the language policy along the lines of Professor Zawada's suggestion. And one finds the minutes of that meeting at bold 642, it's bundle 4, handwritten 652 and 652, handwritten bold 642. And at 653, one sees the introduction of the proposed amendment that gives rise to the present fight. And this is, we're talking about April 2014. 1.7, item 4.2.4 should be amended to read: the language of learning and teaching in all undergraduate and postgraduate taught courses will be English. but with scaffolding in the other official languages as outlined in 4.2.3. All study material, formative and summative assessment, and students' formal responses to the university will be in English, whereas learner support activities may be in the primary language of the student. So that's 3 April 2014, where that principle is put into a proposed amendment that the Senate Language Committee adopts. And since that date, that principle, which is essentially the principle over which Afriforum fights in this case, has been in every version of every draft put forward of the language policy, either to Senate Language Committee, Senate Management Committee, and Senate itself. Now, I counted 14 different meetings where a version, where that principle was in a language policy considered by one of those committees. And I can just give the dates and references to the meetings, and Justice Majid, I will come back with bold number references. These references are all handwritten numbers. 8 April 2014, Senate Management Committee. Bundle 4, pages 683 to 684, paragraph 5.2.1. 19 June 2014, Senate Language Committee. Bundle 4, page 688. 14 October 2014, Senate Management Committee. Bundle 4, page 730, paragraph 5.2.1. 22 October 2014, Senate itself, Bundle 4, page 728, paragraph 8.4.3.6. 21 January 2015, Senate Language Committee, page 746, paragraph 4.1. 10 March 2015, Senate Management Committee, Bundle 4, page 785. 23 March 2015, Senate itself, Bundle 4, page 818, paragraph 10.2. 19 May 2015, Senate Management Committee, Bundle 4, page 823. 26 August 2015, Senate, Bundle 4, page 846, paragraph 7.1. 6 October 2015, Senate Management Committee, Bundle 5, page 864, paragraph 5.2.1. 12 October 2015, Senate Management Committee, Bundle 5, page 867. 21 October 2015, Senate itself, and that's Annexure FA9, core bundle, pages 53 to 54 in bold, paragraph 7.1. And then 11 March 2016, Senate Language Committee, core bundle 68, page 4.1. And so those are 13 in addition to the Senate Language Committee. Sorry, it's not in addition. It is. In addition to the original Senate Language Committee meeting that I referred you to, where the amendment of Prof. Zawada was first adopted. So what one sees there is, first of all, that the Afrikaans lobby at UNISA had 2 full years' notice of the changes to which Afriforum now objects. Nothing was sprung on anyone, and there was no last-minute capitulation to an Afrikaans must fall lobby. What actually happened was that as early as April 2014, this principle had been put forward by the Senate Language Committee. And throughout this entire process, all of the proposals and drafts had 2 principles in common. The first was the proposed new policy would make English the language of teaching and learning at UNISA, and the second was that the historically privileged status of Afrikaans would be removed, And in its place would be put a principle that learner support would be offered in all 11 official languages.
Mr. Chairperson, I don't want to interrupt your flow, but there are two aspects I'd like to raise with you, which emanates from the SCA decision. The first is the point that Justices Theron and Madlanga raised with you. And that's the question of what the decision maker has to take into account and whether that's relevant in a legality challenge like this one. Firstly, it seems to me that the language of section 29.2 itself requires of the decision maker here, like UNISA as an organ of state, to consider educational alternatives. It says the state, and here we know that UNISA as an organ of state must consider all reasonable educational alternatives, including single medium institutions, taking into account certain things. Now, does that not require of the decision maker of UNISA to tell us what it took into account, where we as a court subsequently ex post facto has to consider whether the legality challenge is sound or not?
Justice Majid, my submission in relation to 29.2 and the reference to the state in 29.2 is that it's a reference to the state because it's talking, we look at this case in the context of a tertiary institution and a single tertiary institution. 29.2 speaks primarily to the education system as a whole and essentially to the primary and secondary, primarily to the primary and secondary education systems, which are run by the state as a whole. And when the section speaks of the state having to take account of things, what it's speaking to is the need to come up with a system that will provide a system on a statewide basis that will provide for language or home language learning where it's reasonably practicable. And so it's speaking to those sorts of alternatives that can be considered by a provincial Department of Education, a national Department of Education. UNISA as an individual institution doesn't have the same range of possibilities to consider alternatives. And again, so that's that's my first response to your question. But the second is that the decision ultimately cannot turn on what subjectively served before an individual decision maker. The decision
sorry, just to stop you there. That's not my question. My question is, must UNISA not at least advance what it took into account so that we as a court could consider the legality challenge on the basis of whether in fact UNISA did what it was supposed to do in terms of the section? And that's my question. It's not whether it was taken into account and for us to do a PAJA exercise to see whether that was reasonable or not. It's a question of, must you not tell us what you took into account?
Well, my submission is that one cannot draw a distinction between those two issues. If it's not a PAJA exercise, then the issue is not what was or wasn't taken into account. As soon as it stops being a PAJA issue, the issue is what are objectively, the question becomes an objective question. And it is what objectively are reasonable alternatives, plausible or reasonably practicable alternatives. And that one has...
sorry, finish.
My submission is that one assesses with reference to what the evidence before the court is, not what was or wasn't taken into account.
I asked that question in the context of Hoërskool Ermelo, which decided, and it was confirmed in Gelyke Kanse, that where there is already tuition in a certain language, there's a negative obligation on you as an institution, UNISA, to justify taking it away, to put it colloquially. And in that context, I ask again, must you not advance those factors? And I'd like to refer you to paragraph 42 of gelijke kanse, the judgment of Cameron J. When you are there, I'll just read it. It says the following: earlier, I noted it was the university's own decision-making structures that judged that the cost of securing inclusivity in teaching while not diminishing Afrikaans was too high. Well, who are they to judge that? It is a good question. Certainly, the court owes no obvious deference to the institution making the judgment. And here's the portion I'd like to emphasize. The court must itself scrutinize the facts the institution advances for diminishing language preference tuition while bearing in mind that it is a multifactored functional determination in which the judgment of those entrusted with the institution's well-being should be accorded what this cost has called appropriate respect. This means that when considerations of costs are advanced, the court scrutiny will necessarily be tempered by some measure of deference. So the point I make is for this court to assess the legality challenge, it must consider the facts advanced, the factors advanced by the institution. That's the context I ask it in.
In that context, I'm wholly in agreement with your proposition, Justice Majid. Those facts that are advanced by the institution are the facts that we set out in the heads from page 16, paragraph 23, which relate to the small uptake of Afrikaans modules, the natural attrition of Afrikaans, the inclination of students to want to study in English, the succession of requests to discontinue modules in Afrikaans. 23.4 on page 17 is I would emphasize considerations of equity and the need to correct imbalances in the past, including the fact that it was unacceptable for mother tongue education to be made available for Afrikaans students, but not for speakers of African languages, where UNISA was committed to the redress of imbalances that existed in languages, requiring that active steps be taken to offer programs in other African languages in the form of mother tongue education. And then the status of English locally and internationally, commercial realities, economies of scale, where the numbers of students seeking tuition in Afrikaans didn't justify the cost and effort. And again, 23.8, the fact that to continue in the same vein as before would have been to continue privileging Afrikaans students. And I emphasize that on our facts, we're talking about an Afrikaans student body, 2/3 of which is white, at the expense of students whose mother tongues were other African languages and who had to study in English. So what it would do is it would have required historically disadvantaged students to subsidize historically privileged students, the very opposite of the model demanded by the Constitution. And 23.9, the legitimate concern that if UNISA offered study material in Afrikaans, then it should do so also in other African languages, the absence of which would be inequitable and unfairly disadvantaged students who spoke other African languages. So those are the factors that we submit are the factors to be considered in the context of 29.2.
Now, the second aspect I'd like to take up with you is this question of section 29.2. The SCA and also Afriforum in this court trenchantly criticizes the deponent to your supplementary answering affidavit, Professor Moche, for saying that exactly the point that you just made earlier. You said that section 29 consideration is one for the state. In other words, the state as we understand it in its three spheres, not for UNISA, core organ of state. And Afriforum's point and the SCA's point is that by misconceiving that section 29.2 applies to UNISA, was fatal to UNISA's case on the breach of section 29.2, and that is the ratio decidendi for the SCA in holding that the challenge on the breach of section 29.2 is good. So what do you say of that submission and of the SCA finding?
If we were dealing with a Padgett challenge, then I would have no answer to that. But we're not dealing with a Padgett challenge. We're dealing with a 29.2 challenge, which is an objective test. So if the UNISA decision, if UNISA made a mistake of law, but the objective facts mean that the decision passes muster under section 29.2, the decision does not offend section 29.2, then the mistake of law is irrelevant. It's an objective test. It's not the sort of, which doesn't focus on the subject of inquiry of the decision maker in the way that a Padgett test does. And to give the example, I mean, we do address this argument legally in the heads, but to take the starting point of rationality jurisprudence and the objective test in this court, that was the pharmaceutical manufacturer's case in which the president had put into effect a law on the basis of a law that depended on drug schedules being promulgated. The president subjectively believed, and reasonably because he was informed as much, that these schedules had been promulgated. The court said, no, one doesn't look at the president's subjective state of mind. One looks at objectively, had the schedules been promulgated. Objectively, that was an irrational decision. Having regard to the objective facts, one cannot justify the decision. So the subjective state of mind of the president is irrelevant. And we would submit, and that is true of all objective tests. One looks merely at the facts as proven in evidence, not the facts that were considered by the decision maker or the state of mind of the decision maker or the legal assumptions of the decision maker. One looks at whether the consequence violates a constitutional right or violates rationality, having regard to the objective facts. And so my submission is what the SCA judgment does, is it conflates a Padgett test with an objective test under section 29.2.
I think in all fairness, and just to conclude, I think Afriforum makes that submission, as I understand their written submissions. They make that submission against the backdrop of asserting that when the Senate and therefore afterwards Council took those decisions, there were certain pertinent material factors and information that were not before it, which fundamentally influenced the decision. For example, the demand for teaching and learning in Afrikaans, how many students requested tuition, the financial and human resources required, and the extent to which those resources were feasible for UNISA to continue with tuition Afrikaans. They make that averment, or they make that submission against the backdrop of that assertion.
Indeed, Justice Majid, but my submission is that, I mean, we must bear in mind where this case originated. It originated as a Padgett challenge. What happened is, as the case wound its way through the courts, a case that had been framed as a Padgett challenge could no longer be advanced further as a Padgett challenge because authorities came down saying this is a Padgett decision.
Because of UFS in the SCA and in this court, yes.
Indeed. And so what Afriforum did was to try to repackage its Padgett challenge as a 29.2 challenge. And so all of the arguments that it was making at the level of Padgett about relevant considerations and mistakes of law, it turned into section 29.2 arguments. And the SCA accepted that argument, but our submission is the SCA erred in that regard, because the objective test under 29.2 is not a Padgett test, and it doesn't have regard to what serves before the decision maker. And I want to emphasize the passage at page 8, paragraph 13 of our heads in this regard, because there is a reason for this. And there we say there's good reason that the test of reasonable practicability in section 29.2 is an objective test. The realization of the fundamental right to education is resource constrained, and resources devoted to providing learning in the language of choice of a learner come at the expense of resources otherwise available for realizing the fundamental right to education. If the objective facts show that it's not reasonably practicable to provide education in a particular language of choice, the fact that a decision maker did not have regard to those objective facts or misunderstood the nature of his/her discretion does not oblige the courts under section 29.2 to enforce an inappropriate utilization of education resources that will privilege some learners at the expense of others. It's an objective test that doesn't have regard to what served before the learner. And I also want to emphasize in this context that Section 29.2 is a socioeconomic right. And particularly in the context of Section 29.2 and higher education, there's no unqualified fundamental right to higher education. So how the state and the universities use their resources in relation to higher education is a place where the court should get involved with some deference, because Section 29.2 should not be invoked in respect of higher education in ways that will distort the equitable use of resources by a university. That would really subvert the structure of Section 29 as a whole when it's interpreted in the context of a constitution that has a transformative objective.
Chairperson, I'm sorry. It may be that you're still going to come to details on the interpretation of Section 29.2. But I think I should, before I forget, raise some issues with you which I need clarity on. When we read Section 29.2, do we have to understand it in the context of the entire section, including subsection 1?
I'm sorry, Justice Jafta, I just lost you there.
Okay.
When we read Section 29.2?
Do we read it in the context of the entire section 29, which includes subsection 1 of Section 29?
My submission is yes. Okay. And what flows from that is that when it's invoked in the context of a tertiary education institution,
yes,
this court should stand off more than it would if it were invoked in the context of a primary or secondary school.
Okay.
Because there is an unqualified right to primary education.
Yes. Yes, carry on.
An unqualified right to basic education, but a very seriously qualified right to further education.
Yes.
Which means that that is a place where state resources, which is subject to state resources.
Okay.
So what one shouldn't do is invoke Section 29.2 in relation to tertiary institutions in a way that will force a particular allocation of resources at a tertiary level. What the Constitution says is that there is very limited scope to get involved in allocation of resources at tertiary level. And what this case does is it really says, get involved and force UNISA to allocate its resources in this particular way, in a way which will benefit for the most part white Afrikaans-speaking learners and make African language learners subsidize white Afrikaans-speaking learners. That is something that I would submit Section 29.1 and 2 read together would strongly counsel against.
Okay. Doing so, I would want to understand the difference, if any, between the test of reasonable measures mentioned in sub 1B and reasonable practicability that is mentioned in subsection 2. Is there any difference?
I can't, in truth, Justice Jafta, I would be talking off the top of my head if I gave you an answer to that question. I can't sensibly suggest there is a distinction. What I would emphasize, however, is that for the most part, sub 2 is framed with a concern for the education system as a whole, not for individual institutions. It's framed with what subsection 2, in particular, when it says, in order to ensure the effective access to and implementation of this right, the state must consider all reasonable educational alternatives, including single medium institutions, taking into account equity, practicability, and the need to redress the results of past racially discriminatory laws and practices. What that is recognizing is that sorting out language-based learning in education, in an education system as a whole, is bigger than one institution and cannot primarily be the responsibility of an individual institution, because it's something that the system as a whole must deal with.
And am I right to say the reasonable measures test in 29 sub 1B is designed to apply in a situation where someone does not as yet enjoy a socioeconomic right? It is future looking forward, that the state should take reasonable measures to make that the realization of that right progressive. Am I wrong?
Well, Justice Jafta, I would submit that there are both future and past-looking measures in both 21B and 21.2. So this court has repeatedly emphasized that all socioeconomic rights have a negative element to them. So they're not just about extending the provision of the right in the future. They also implicate measures that impinge on existing realizations of the right. And that's been a principle of the socioeconomic rights jurisprudence of this court, I think all the way back to Grootboom. Likewise, in 2, I think this court has emphasized in, certainly in gelijke kanse, that sub 2 has both a negative and a positive dimension to it, both a forward-looking and a backward-looking dimension to it. But what I would emphasize from gelijke kanse is that this court held at paragraph 24 of gelijke kanse that the test of reasonable practicability is not one that is stricter when language policy is changed to remove teaching in a particular language than when language policy is not developed to introduce teaching in a particular language. It's the same test whether one's dealing with the negative aspect of the right or the positive aspect of the right. One can't say because there was Afrikaans learning and Afrikaans will no longer be a language of teaching and learning at UNISA, there is a higher burden on UNISA. That argument was rejected by this court in gelijke kanse.
So should you see, Mr. Chairperson, I was trying to understand whether when we are approaching this matter, should we approach it on the footing suggested in Worskol Emelo as a situation where the right was already being enjoyed and now it is being taken away, And if we adopt that approach, it seems to me it waters down the argument based on the privileged status of Africans, which is based on historical circumstances. Rather, one has to look at the fact that those students who had preferred to be or to study in Afrikaans were already enjoying the right, and therefore, if that enjoyment is taken away, can we still look at the fact that Afrikaans was privileged and in the past order when the Constitution itself recognizes Afrikaans as one of the official languages? And I think in section, is it section 6 that deals with languages? It lists the official languages, and in sub 2, it says recognizing the historically diminished use and status of the indigenous languages of our people. The state must take practical and positive measures to elevate the status and advance the use of these languages. And I thought for a moment when you were debating the issue of indigenous languages with Justice Majid, you had in mind subsection 2 of section 6, which seems to direct indigenous languages to those which had a diminished use of in the past. But when dealing with the issue of changing the language policy and taking away the enjoyment of learning in Afrikaans, should we still look at that historical aspect?
Well, Justice Jafta, the first principle is that the test of reasonable practicability is no higher because there was teaching and learning in Afrikaans and UNISA, and there will no longer be, than it would have been if there had never been and it wasn't going to be introduced. It's the same test according to Gelyke Kanse. It's not a different test. The second answer is an answer at the level of fact, that in terms of individuals who carried the right, who actually enjoyed the benefit of the right, their rights were not taken away. So the students who were studying in Afrikaans were protected by the transitional mechanisms which said you can carry on your line of study to the end of your degree. You will have Afrikaans modules in second year and third year. So their rights are not affected. So the question then becomes, does 29.2 mean that one cannot have regard to the history of Afrikaans? 29.2 read with section 6. Does it mean one cannot have regard to the history of Afrikaans in deciding whether to continue Afrikaans language and learning at an institution? My submission is no, because if the consequence of the policy is that you are looking to African language speakers at UNISA essentially to subsidize Afrikaans language speakers, the overwhelming majority of whom are white at UNISA, then that is a very relevant factor in whether it is practicable to continue it. If you have a situation where UNISA is much better resourced, and it will, and resources, and the state has prioritized language of learning funding in a way that it doesn't, And there are ample resources to go around to essentially to build up African languages to the level where they can be used, to build up the academic infrastructure to use African languages as languages of tertiary education, teaching and learning. If you have those resources, and you have the resources to deal with providing teaching and learning in African languages, then you can't, as it were, single out Afrikaans and penalize it because it was historically a language linked to apartheid. That the Constitution wouldn't tolerate. But where you are tightly resource constrained and you don't have the resources to provide teaching and learning in African languages, and your existing policy effectively says that African language speaking learners are going to subsidize Afrikaans language learners because we will devote all of these resources to providing a parallel medium of instruction when the demand for that medium of instruction is solar, and we've talked about that demand. Then I submit that it is a very legitimate concern under Section 29.2. You're resource constrained, and why should an institution that is resource constrained be forced to privilege any one language in terms of the allocation of resources, particularly not to privilege a language that is historically privileged under apartheid and where the cost of continuing that historical privilege is going to be borne by the historical victims of apartheid. That, I would submit, is a perfectly legitimate concern in the context of 29.2.
Doesn't that suggest, Mr. Chairperson, my concern is that approach to the enforcement of socioeconomic rights, doesn't it suggest that you would have a stage where the state would have taken reasonable measures to see to it that a particular right is enjoyed? Then if resources available to the state change, we can regress and we have the enjoyment that was already there being lost on account of the available resources. And what concerns me would relate to rights like of access to adequate housing or access to healthcare. I'm worried about this approach that says, okay, you can have people enjoying this right today because the state can afford. But tomorrow, the same people or other people may not enjoy the same right because the state has decided that the resources don't permit.
Well, Justice Jafta, there are really two answers to that concern, I would submit. The first is, if the state can genuinely show, well, let's deal with Section 29.2 first, because the first answer is one doesn't have to get to healthcare, housing, or even basic education in the context of this debate. Because the one thing this court has made clear is that the test of reasonable practicability, whether you take away existing language of learning or whether you fail to develop language of learning where it isn't, is exactly the same. So once it is clear that the resource constraint argument applies in relation to not developing language of learning where it doesn't currently exist, then it must equally apply in relation to a situation where language of learning does currently exist. And indeed, this court in Gelyke Kanse made that clear, because it said cost is a legitimate concern in relation to section 29.2. So the test is the same whether one's talking about, if I can call it, the positive or the negative aspect of the right in relation to 29.2. And this court has made clear that cost is relevant. Cost and resources are relevant. Whether that is a test that, whether that approach would apply equally to all of the other socioeconomic rights, food, social welfare, housing, healthcare, is an issue that this court doesn't need to decide today. Principally because the language of section 29.2 is not the same as the language of the other socioeconomic rights. The language of the other socioeconomic rights is more the language of 29.1b, which talks about reasonable measures that make rights progressively available and accessible. And in the notion of progressive, there may be the ratchet effect of the sort that you're describing, Justice Jafta, that once you've advanced a right to a certain level, that's a flaw and you can't drop below it. I'm not saying there will be, but certainly in that language, you can find that reasoning. But one doesn't see that language in 29.2 at all. It's in 29.1b.
That is why I asked earlier on, remember, whether there was a distinction between the standard of reasonable measures in 1b and the reasonable practicability in 2. So it seems you are saying there is a difference.
Indeed, Justice Jafta, through your engagements with me, I'm no longer talking off the top of my head and have found a sensible difference. But that would be my submission, that this court need not concern itself with the concern that you're expressing in relation to rights like housing, welfare, healthcare, because 29.2 doesn't speak to the obligation to make rights progressively available and accessible. And it would be through that progressive availability and accessibility that the notion of no retreat could come in.
My last question, even though it is on an issue that you're still going to touch on, just when you come to it, I would like you to address the issue of what is the appropriate remedy where a test like reasonable practicability is found to have been breached. In the context of reasonable measures, our jurisprudence tells us that it is not for the court to take decisions that should be taken by the executive in implementing the rights. If the measures are found not to meet the reasonableness test, the court has to set aside the measure and leave the matter to the executive. When you come to the issue of remedy, would you address that?
I will, Justice Jafta, but before I get to remedy, I just want to complete my submissions on the merits. I think through our exchanges, I've really traversed everything in relation to 29.2 and reasonable practicability. I don't want to add anything to what's set out in the heads, but I do want to address the process argument, because as a second argument, although it doesn't form part of the SCA's judgment, Afriforum has said this was an irrational process. And I've talked about the fact that nothing was sprung on anybody overnight, but I do want to talk now more specifically about the limits of procedural irrationality and its application in this context. The core of Afriforum's argument about procedural irrationality, which is really the only place in which process could be relevant to the decision, is that UNISA allegedly failed to consult Afrikaans language students in making the process. And it says it was the Afrikaans language students who were going to be primarily affected by the language policy. It was irrational not to consult them. Now, the basic flaw in that argument is that the policy didn't affect the rights of existing Afrikaans students, because their rights to continue on Afrikaans language modules to the end of their degrees was protected. I've talked about that in the context of the implementation plan. And Afriforum itself even concedes as much when it has to explain why there's been not a single complaint about the policy from students. And I want to emphasize that fact. There has been not a single complaint about the policy from students. If one goes to the Afriforum replying affidavit at bold 525, handwritten 535, paragraph 42.2, the following is said: it's not surprising that current students would not have complained, because students that have commenced their studies in Afrikaans in 2016 or earlier are still studying the modules in Afrikaans. They were probably given to understand that, as stated by the deponent in the initial answering affidavit, they'd be able to complete their studies in Afrikaans. So Afriforum acknowledges that existing Afrikaans students have not been harmed. So the process complaint then becomes a complaint, not that UNISA didn't consult existing Afrikaans-speaking students, but prospective Afrikaans-speaking students. One sees prospective students at various points in the Afriforum papers. But who are prospective Afrikaans-speaking students? They are the entire Afrikaans population with matric certificates. Afriforum doesn't suggest how UNISA should have consulted with the entire Afrikaans population holding matric. And if UNISA had to consult the entire Afrikaans population that holds a matric certificate, it would equally have had to consult with the entire population of African language speakers who hold matrics, or who will hold matrics in the future. Because their rights, the rights of African language speakers, would be adversely affected if the policy wasn't adopted. Because far more important in the policy, in our submission in relation to what the policy did, was advancing for the first time ever dedicated language support in all official languages. So if you've got to consult with Afrikaans language speakers, you've got to consult equally with African language speakers. Now, what this effectively means is that there was a duty on UNISA to consult with the entire population of people holding matric in South Africa, and possibly high school students as well who might hold matric in the future. Now, with respect, I submit that that notion of a consultation duty is absurd. But even if it isn't absurd, it plainly falls far, far, far beyond the very narrow confines of a consultation duty under the rationality test. We're not talking about PAJA. We're talking about the very, very narrow grounds of procedural irrationality. So we submit that that procedural irrationality argument cannot be sustained. That brings me to the issue of remedy. Now, our primary submission is that UNISA should succeed on the merits and the appeal should be upheld on the merits. And the order to be substituted by this court is an order which would dismiss the application of Afriforum. But if this court is not with us on the merits and finds that there was a constitutional flaw in the new policy or in its adoption, the question of appropriate remedy arises. And it arises very, very seriously in a context. Yes, sorry.
I'm sorry to interrupt you. I'm sorry to interrupt you before you've even addressed the question of remedy, but I have a few concerns around the remedy. Perhaps I can raise these with you. If this court finds that the revised language policy violates section 29(2), and it suspends the order until the beginning of 2023 academic year as requested by UNISA, it will in effect allow UNISA to implement an unconstitutional policy for almost 1.5 years. And what concerns me is how could that ever be a just and equitable remedy? And I'm not sure that UNISA has properly dealt with the discontinuation policy. If the SCA's order is subject to the 2010 policy and the discontinuation policy, isn't it so that UNISA would only be obliged to reintroduce the Afrikaans as a module if the discontinuation policy doesn't warrant its discontinuation? Because I know in its papers, UNISA has made some complaints or some noises about the discontinuation policy in terms of the SCA judgment.
Well, on the terms of the SCA judgment, UNISA couldn't do that. So on the terms of the SCA judgment, UNISA has to reintroduce all modules that were offered in April 2016, I think it is.
I don't understand that. Wouldn't it be subject to its ordinary discontinuation policy?
Well, not on the SCA judgment, but that's a detail of my concerns with the SCA judgment. The SCA order is at paragraph 22. Is quoted at page 22 of the head's paragraph 23. And what UNISA is obliged to do under the SCA judgment is to publish on its website and in 3 major Afrikaans newspapers and to transmit by email to all of its students a notice that contains a full list of the modules that were on offer in Afrikaans as at 28 April. And that notice must offer all prospective students for the next academic year admission in such modules. So included in that list of modules will be a whole series. Take the life sciences example. Assume where we saw that all 49 modules in life sciences were had satisfied the requirements for discontinuation under the guidelines. If the policy were to be reintroduced, or if the SCA order were to be imposed on UNISA, or to be upheld by this court, the Life Science Department couldn't come back to the Senate Language Committee and say, well, back in 2016, we asked to discontinue these modules. In the meantime, as far back as then, there hadn't been a single case of 15 Afrikaans students wanting them for the last 3 years. Obviously, they haven't been offered for the intervening 4 years. So for the last 7 years, there haven't been any takers for these courses. Quite aside from the fact that we no longer have people who are qualified to teach them in Afrikaans, and we don't have materials to teach them in Afrikaans. We're lucky because we can show that they felt to be disqualified under the old language guidelines. It couldn't do that because it's obliged under paragraph 2 of the order to offer all prospective students for the next academic year admission in such modules. So it can't invoke the guidelines for the remainder of the year. And then in that respect, the SCA order actually goes further than even the existing policy. What it does is it imposes obligations that go beyond the status quo beforehand. So in that respect, at the very least, we submit that this order is bad at the level of remedy.
Mr. Chairperson, if I could just follow that up and understand it. What you say then is if, for example, a module in the life sciences had fewer than 15 Afrikaans speaking students, the discontinuation policy guidelines allowed UNISA to take a decision to discontinue. But this order goes further than that. It says that the guidelines can't be followed. You must still offer it regardless of the fact that there's fewer than 15 students. That's what you say.
At least for the first academic year after the order, indeed.
Yes. Okay. Yes.
It goes further in another respect in paragraph 3. It says, offering all existing students, if they were enrolled in any one of those courses, or would have enrolled for the subsequent year course in Afrikaans, but had perforce to follow the module in English, a choice to enroll on the basis that they may follow the module in English until completion of their studies. So it means that even in the second and third year courses, where the old guidelines would have allowed discontinuation, those courses must be held available in Afrikaans for another 2 years henceforth. So it clearly goes beyond the old guidelines. But my primary concern with the order is not this. My primary concern is that the order at the level of remedy just turns a blind eye to practical reality and to the passage of time. Justice Turon asked, could it ever be acceptable for UNISA to keep in place an unconstitutional policy for 18 months? Now, with respect, Justice Turon, this court often does that in relation to laws that Parliament enacts. So a period of suspension of 18 months for an order of invalidity is something that's frequently done by this court in relation to
UNISA hasn't asked for a suspension in this matter, Mr. Chairperson.
No, with respect, it has it did at a certain point on the papers. I can find that reference. There was
perhaps you can continue with your argument, and your
yes.
junior can assist Mr. Chairperson to find the reference.
But there is a broader concern, Justice Turon, which is a lot of water has flown under the bridge since this case was launched. So we sit today in a situation where we are now 5 years down the line since Afrikaans language was offered at UNISA. In those 5 years, UNISA has been administering its affairs, dealing with staffing issues, dealing with curriculum issues, dealing with resource issues, without having to provide for Afrikaans language instruction. Now, to turn the clock back to 2016 overnight, which is what the SCA judgment obliged UNISA to do, is simply not practical at all, because the curriculum moves on in 5 years. Anyone who's taught in a university knows that the materials that you use today are completely different to the materials you used 5 years ago. Staffing moves on. UNISA presumably has an employment equity plan which has resulted in significant changes in the composition of its staff. It's to suggest that tomorrow UNISA can simply just reinstitute the Afrikaans modules that were there in 2016 is completely unrealistic and impractical. UNISA needs to look at what resources it's going to have to hire people. It's going to have to It's going to have to produce new materials. It's going to, that cannot just be done.
Sorry to interrupt you again. In the directions that this court issued, some of these questions were raised. Why hasn't UNISA undertaken these assessments? And why haven't they placed facts before this court that demonstrate that it is simply impossible to revert to the old policy by the 2022 academic year if this court was minded to find that the current policy is unconstitutional?
That, I'm afraid, Justice Trona, I have no satisfactory answer to. I must concede that that there was an opportunity to put new facts before this court, and UNISA did not take that opportunity. But I would submit nonetheless that this court can have regard to practical reality. And there are other issues. One is dealing with economic constraints. One is dealing also with a situation where UNISA, if the SCA judgment is upheld on the merits, UNISA will have to reflect and consider what it can and cannot do in terms of language policy consistent with the Constitution. So it will have to, it's not just, it will have to reinstitute the old regime. If it doesn't have the resources to do that, then it has to think quite carefully about what alternative regime it can put in place that will be consistent with the Constitution. That's not a process.
I know you said, Mr. Chasconsel, you can't take it any further, but the directions that this court issued in October specifically raised those questions, and UNISA did not respond. October last year.
I cannot take it further beyond beyond referring to general concerns, which I would submit would flow naturally in any situation. You're a university 5 years down the line in which you haven't provided Afrikaans language instruction. You have no materials that are less than 5 years old. Your teaching staff is no longer a teaching staff that has been framed with the need to provide parallel Afrikaans instruction, precisely because you didn't want to use resources to subsidize the historically privileged at the expense of the historically disadvantaged. This is not something that can be cured overnight. It just cannot. And it would have been, if UNISA had provided me with very specific facts, I would have been overjoyed. And I accept that there is a consequence that those facts are not before this court. But at a level of general proposition, there are certain assumptions that this court cannot ignore. To force this back on UNISA overnight in the way that the SCA did is really to impose an inappropriate burden on an organ of state, because what the SCA judgment does, and it comes back to a certain extent to Justice Jafta's, the issue that Justice Jafta raised with me. The SCA judgment forces UNISA to put in place a policy that was UNISA's policy from 2010 to 2016, and that UNISA consistently wanted to change. That's what the SCA judgment does. What the SCA judgment doesn't do is give UNISA the opportunity to reflect again in the light of a judgment on that policy and to decide what an appropriate policy is today. To do that requires a suspension of invalidity. And in relation to Justice Jafta's remedial question about separation of powers and what is and isn't appropriate for a court to do it at the level of remedy, my submission is that if the court is against us on the merits, a suspension of invalidity cries out in this case. This case cries out for a suspension of invalidity, because one needs time to put in place an appropriate language policy. The existing one clearly isn't appropriate. It's common cause. And what the court should not do, I submit, is to force UNISA to reinstitute a policy which, on any understanding, is no longer an appropriate policy. Can I?
Mr. Chairperson, before you move away, let me understand, I'm a bit confused by paragraph 2 of the order. Paragraph 2 says the order of the Koraku is set aside and replaced with the following. A, the resolutions of the Council and Senate of UNISA to approve a new language policy on 28 April and 30 March 2016, respectively, are set aside. Let me stop there. If those resolutions are set aside, can the new policy survive? If one accepts that the setting aside of the resolutions of those two bodies of UNISA, where the setting aside was correctly made.
Can the new policy survive?
Yes, still stand.
Only if there is some qualifying order under 172.
See, now B, what creates a problem for me, B says, the new language policy adopted by UNISA is declared unconstitutional and unlawful, and it's set aside to the extent that Afrikaans has been removed as a language of learning and tuition. And correct me if I'm wrong, my understanding of B is that the setting aside of the policy is limited only to it making reference to Afrikaans.
I think that is the intention of B. That's certainly the intention of B. I think A and B could have been framed possibly with more elegance, but I do think that's the intention of B.
Is there no contradiction between A and B?
Well, my submission is, if one had to interpret the order as a single composite document, one would have to interpret B as qualifying A, because I think otherwise there is no sensible meaning for B. But even if this court is against us on the merits, we would submit that the order should be cleaned up so that there's no ambiguity.
Yes, my problem is, and if I'm wrong, correct me, I thought for policy, the language policy at UNISA to be valid, it must be approved by the appropriate bodies within the institution. Now, if the court says the approval that was given by those relevant bodies is set aside, who would have approved the policy now?
No one would validly have approved the policy in terms of the order.
Now, can we still speak of a portion of that policy that survives because we find that portion to be objectionable? It seems to me it's something that can be equated to legislation that was passed by Parliament following the wrong procedure. And if the court upholds that the procedure adopted in passing that legislation was wrong, then the entire legislation falls. You can't say the invalidity is limited to a particular objectionable section of the legislation? Or am my thinking is wrong?
No, Justice Jaft, if one attacks the if one attacks the process,
Yes.
then certainly one cannot cherry pick what does or doesn't stand. And the solution is either to strike everything down or to strike it down with a suspension of invalidity.
Yes.
And if one attacks the substance and leaves aside the resolutions, it might notionally be possible to speak to a severable inconsistency with the Constitution. Yes. So one did away with B and just did away with A and left B could plausibly stand on its own. But then it would have to be because this court finds that objectively the removal of the status of Afrikaans was inconsistent with the Constitution. That was the narrow ambit of the constitutional problem. But I do want to emphasize that how UNISA is to go forward from here is a matter in the first instance for UNISA to decide. And it shouldn't have to decide that in the face of a series of resource constraints imposed by decision that forces it to spend money going backwards to where it was in 2016. That, with respect, would be an intrusion into the executive, or into another branch of government. And so this is a case that calls for a suspension of invalidity, and a suspension of invalidity that will give UNISA enough time to decide how to go forward if this court finds that it has acted inconsistently with the Constitution in adopting the 2016 policy. And time at a university is time that is linked to the university calendar. So that if this court hands down judgment tomorrow, it may be that a suspension of invalidity can run to the start of the 2022 calendar year. But if this court takes time over a judgment and hands it down in August, well, then there isn't time to put things right before the start of the 2021 calendar year, and then a suspension needs to run to a 22 calendar year. And in that regard, the issue of a suspension was canvassed on the papers. Mr. Wesley's given me the reference. It's the supplementary answering affidavit, bundle 3, page 436. Paragraph 12.6, where UNISA says, for the reasons set out below, UNISA respectfully submits that none of the relief. Sorry, Mr. Wesley's just informed me. I've given the bold number. The bold number is 436. The handwritten is 446. And there the following is in the supplementary answering affidavit. UNISA respectfully submits that none of the relief claimed by Afriforum is well-founded. If, however, this court were to conclude that Afriforum is entitled to any of the relief it claims, UNISA respectfully submits that an order embodying any such relief should be suspended for a period of 9 months to allow UNISA time to reconsider its language policy in the light of the judgment in this case. In this regard, I point out that by the time any judgment is issued in this matter, UNISA's new language policy will have been in operation for 2 academic years, and it will not practically be possible to revert overnight to the position that obtained at the start of the 2016 academic year in relation to the provision of modules in Afrikaans. I submit that that is a proposition that stands self-evidently, and that if this court is against us on the merits, the only appropriate remedy would be a suspension of invalidity. And the suspension of invalidity would be one that had to be tailored to a reasonable period before the start of an academic year. Justices, those are my submissions, unless there are any specific questions that any members of the court want to put to me. I've long exceeded the 45 minutes. I promised the acting Deputy Chief Justice, but I apologize for that.
Thank you, Mr. Chairperson.
Thank you.
Mr. Cockrell.
Thank you, Acting Deputy Chief Justice. Acting Deputy Chief Justice, Justices of the Court, I'd like to use my 10 minutes, if I may, to sketch what this case is about from Afriforum's perspective and what this case is not about. And I've listened very closely to my learned friend this morning, and I've listened to the engaging debate between him and the members of the court. And let me see if I can snapshot the case in 10 minutes before I get to the detail. Let me start with what this case is not about. UNISA's heads of arguments suggest time and time again that what this case is about is requiring UNISA to offer tuition in Afrikaans in all modules. With respect, that is not correct. That has never been Afriforum's case. The case is not about requiring UNISA to offer tuition in all modules. The case is about requiring UNISA to continue offering in Afrikaans the modules that were being offered in Afrikaans at the time when the new language policy was introduced. And for our purposes, we'll take UNISA's numbers, because what UNISA says in its affidavit is that at the relevant time, there were 300 modules in Afrikaans being offered out of 2,300 modules in total. So on UNISA's own numbers, 300 modules out of 2,300 modules were being offered at the time. If one does the maths, it's 13%. So from Afriforum's perspective then, what is this case about? Well, Afriforum's argument goes like this. At the time when the new language policy was introduced, those 300 modules were being offered out of the 2,300. Those modules were being offered in Afrikaans, but were not being offered in other languages. That triggers the Hoërskool-Ermelo reasoning. And the Hoërskool-Ermelo reasoning of this court means that UNISA must establish appropriate justification for abrogating the continuation of tuition in Afrikaans in those 300 modules. I need to be clear about this. The question from Afriforum's perspective is not whether UNISA should offer more tuition in Afrikaans. The only question is whether it acted impermissibly in abrogating the tuition in the 300 modules that was happening at the time. In that respect, Afriforum says it has a right to a decision made by UNISA that must be constitutionally compliant, it must be rational, and it must be made in accordance with UNISA's own rules. All of those legality-based challenges, nothing to do with PODGA. And the case for Afriforum is that UNISA's decision didn't satisfy any of those requirements. And I'm going to indicate in due course that with the greatest of respect to UNISA, it is an extraordinary feature of this case that you will not find anywhere in the record, the contemporaneous record, you will not find a reference to the considerations in section 29(2) of the Constitution. The considerations listed in 29(2), A, B, C, you will not find referred to anywhere in the contemporaneous record of UNISA's decision. Now, Acting Deputy Chief Justice, members of the court, we accept that in advancing this case, Afriforum has to navigate around two beacons of this court's jurisprudence. The beacons are the University of the Free State case and the Gelyke Kanse case. And I'm going to submit to you in due course that those two judgments, in fact, support Afriforum's case in the present situation. And I'm going to make that submission for two reasons. I'm going to say the UFS case, the University of the Free State case, the reasoning doesn't apply precisely because UNISA is a distance learning institution. It doesn't have classes. And so what happened in the UFS, that in effect there was a racial division between who was in the classes. That doesn't arise in the case of UNISA because UNISA doesn't have any physical classes. And when it comes to gelyke kanse, I'm going to submit to you that gelyke kanse shows that the University of Stellenbosch did the maths when it came to costs. They worked out to the last rand how much it would cost them to continue their existing policy, and they put up those facts to the court. As I recall, it would be an additional 8,000 rand on top of the 40,000 rand paid by students at the time. So they did the sums and they came to the court with a cost calculation. And with respect, that is not something UNISA has done, because you will hunt through this record in vain to find any reference to what the costs are of continuing the old language policy. Acting Deputy Chief Justice, I'm going to submit to you with respect that if UNISA's decision to discontinue tuition in Afrikaans were to be upheld, then it's difficult to imagine that a challenge to a decision to discontinue Afrikaans at a tertiary institution could ever succeed. And so we listened, and sorry, let me make it clear. I make that submission because, as I'll indicate in due course, the record of its own decision is so unequivocally against UNISA. It simply can't find any reference in its own documents to section 29.2. And so we listened closely to our learned friend today to try and understand what is UNISA's real case. And at the end of the debate my learned friend had with the court today, we understand UNISA's case to be this: ignoring the fact that there's nothing on the record about costs, ignoring the fact that there's nothing on the record referring to 29.2, it was nevertheless justified of UNISA to discontinue tuition in Afrikaans, because to do so would have continued to confer a benefit on Afrikaans-speaking students who have historically been the beneficiaries of apartheid. Acting Deputy Chief Justice, members of the court, in response to that argument, which seems to us to be the real UNISA case, I can do nothing to improve on what the president of the SCA held. I'm going to read to this court what she said in paragraph 44 of her judgment, which was the judgment of the SCA. In striking down the policy, she said, "To find otherwise would, in my view, mean that the mere exercise of one's right to be taught in their mother tongue would be rendered unconstitutional, where it has not been shown that non-Afrikaans students would be deprived of learning and other educational opportunities by the retention of Afrikaans as a language of learning and tuition, or that maintaining it as a language of learning or tuition was unaffordable, or would result in unlawful racial discrimination in an institution of learning with a proclaimed ambitious vision to promote multilingualism by developing all the official languages, including the SAN languages." In other words, if I can summarize in less erudite language, what the SCA was saying is UNISA must put out the facts to make that decision. And with respect, it simply hasn't done so. And so, Acting Deputy Chief Justice, at the end of the day, the submission I'm going to make to this court is one goes back to the judgment of this court in the UFS case, the University of the Free State case, and I'm going to read to you what this court said in paragraph 51 of its judgment. So this court speaking. In this case, it was through the words of the Chief Justice. Paragraph 51, at a conceptual level, dual medium institutions might well exist without necessarily nurturing or perpetuating unfair advantage or racial discrimination and its exceedingly harmful tendencies. When that is so, then the right to be taught in a language of choice could be effectively accessible and implemented. Very hypothesis this court contemplated in UFS and the submission I'm going to make is one will not find a clearer real-life example of that hypothesis than UNISA, because of the fact that it is a distance learning education institution. Acting Deputy Chief Justice, members of the court, those in a few minutes, that is our understanding of the case, but let me indicate to you the roadmap of what I intend to argue. I'd like to begin with the section 29.2 point, which took up most of the debate this morning, and understandably so. I'm going to spend some time on section 29.2 of the Constitution and why it was violated by UNISA when it made the decision. I'm then going to make some very brief arguments regarding rationality, which my learned friend Mr. Chaskelson did deal with. The third part of my address, if time allows, I'm going to make some very brief submissions regarding legality, and in particular why UNISA didn't comply with its own rules when it made the decision. And then fourthly, I'm going to spend some time on remedy. In other words, what remedy should be granted by this court if it were minded to dismiss the appeal on the merits. And those are the issues which I intend to address. Let me start then with section 29.2.
Mr. Cockrell, your 10 minutes protection time has expired.
Thank you. Well, then I've done well with timing, Acting Deputy Chief Justice, because the protection I wanted was really just to snapshot the case.
Mr. Cockrell, may I just ask you about your roadmap? Yes. In your written submissions, you spend some time on the new facts, the new evidence introduced by UNISA. Given the difficulty with the remedy here, do you still stand by them, or do you accept that it was proper for UNISA to advance new facts in their submissions?
No, with respect, we maintain our submission, Justice Majid. In fact, with respect, it's even worse for UNISA. When the directions were given by this court in October last year, those are the directions Justice Theron referred to, they were invited to put up new facts should they think it necessary to do so, and they elected not to. And Justice Majid, I'm going to give you the reference since my learned friend didn't refer to it. You'll find that, if you can just bear with me. Yes, it's page 1287, it's paragraph 6, Justice Majid. And that's where, when UNISA responded to the first directive, it said it was not going to put up any new evidence. If the evidence was relevant, it ought to have applied to reopen its case and to place the fresh evidence before the court. But having made that election not to do so, Justice Majid, with respect, it's not permissible for them to do so through their heads of argument. So we do persist with that submission.
Yes, thank you.
May I then go back to the first item on my roadmap, which is the section 29.2 case. And I am going to ask the court to go to one part of the record. I don't think I'm going to take the court to another part of the record today, but I am going to ask the court, please, to go to volume 3, page 461. Justice Majid, the page numbers I have are the handwritten pages, but I'll do what my learned friend did and give you the typed, the bold pages as well. So it's handwritten 461. It's bold 451, Justice Majid.
Thank you.
And this is the supplementary answering affidavit of UNISA. So it's UNISA talking, not my client. And this is what the deponent says in 49.7. The considerations that are mentioned by Afriforum would arguably be relevant to the state when it's required to fulfill its responsibility in terms of section 29.2 of the Constitution to ensure the effective access to an implementation of the right concerned. But they are not relevant to UNISA when UNISA determines its language policy. As opposed to the state, UNISA is not liable to ensure the effective access to an implementation of the right concerned in the Republic. Well, that's UNISA's deponent speaking. And with respect, she's wrong, because this court has held to the exact opposite in the UFS case and in Gelyke Kanse. In both of those judgments, this court has held that the institution making the decision, UFS or University of Stellenbosch in those two cases, is indeed bound by Section 29.2 and is required to give effect to Section 29.2 when it makes the decision. And so, in the light of that statement in the answering affidavit, it's not surprising that when one goes to the record of UNISA's decision, nowhere will you find in the record documents any reference to Section 29.2 of the Constitution. It's not there because UNISA took the view it wasn't bound by Section 29.2. And the easiest way to do this, I'm not going to do it with you, but if you go to the reasons document of UNISA, that's the reasons document that they put up for their decision. In that reasons document, you will not find a reference to Section 29.2 of the Constitution. So with respect, what we know from the record is that at the time when UNISA made the decision, it didn't have regard to the considerations in Section 29.2. It is correct that in the affidavit, the UNISA deponent says time and time again that UNISA did have regard to Section 29.2. But the record, the documents in the record are simply against her. There's nothing to show that. And it's not that surprising that there is no reference to 29.2 because the deponent says on affidavit, UNISA didn't regard itself as being bound by Section 29.2. Now, Acting Deputy Chief Justice, most of what I've just submitted to you is entirely common cause. Where we part ways with our learned friend is our learned friend says, well, that's correct, but it doesn't matter because 29.2 is an objective inquiry. It's not a subjective test that would apply if this were a PUDGA review. And I need to respond to that argument because it formed the basis of much of the debate between my learned friend and the justices of the court this morning. And with respect, it's a very important debate. Let me start with this. It's correct that the test under 29.2 is objective. It's what this court has held. So we accept that. But what that means is that it's not enough for the decision maker to say, I applied my mind to 29.2 and I was satisfied that my decision was correct. The fact that it's an objective test means that a court can always say, the fact that you, UNISA, or UFS, or US, formed the view does not immunize your view from being second-guessed by a court. In other words, a court can say you got it wrong because the test is objective. We agree with that. But the fact that the test is objective doesn't mean that it doesn't matter whether the decision maker ever applied its mind to 29.2 at all. And that's a submission made by UNISA. UNISA says because the test is objective, it doesn't matter whether they did or didn't have regard to 29.2. But with respect, if that were right, UNISA could make this decision without even being aware of 29.2 and could then come before the court and can say, it's true I didn't apply my mind to 29.2, but you, the court, are now the objective decision maker, and let me give you a library of documents, and let me then hope that you will form the view that the decision I made was the correct one, even though I didn't go through the discipline of 29.2. Well, with respect, that is not what 29.2 says, and one finds the textual marker in the second part of 29.2, which says, in order to ensure the effective access to an implementation of this right, the state, which in this case is UNISA, qua organ of state, must consider all reasonable educational alternatives, taking into account, and there follows A, B, C. So the injunction is the state must consider, in this case, UNISA must consider. It's correct that afterwards a court can decide whether the state, or in this case, UNISA, got it right or wrong. But what UNISA can't do is short circuit that step and say, I come before this court and I ask you to decide whether my decision was objectively correct, even though I didn't have regard to 29.2. That is not the structure of 29.2. If UNISA were correct, what would happen is that on every occasion when a decision of this nature is taken, a panoply of documents would be placed before a court and it would be asked to decide objectively whether the discontinuation was permissible or not. Well, that is not how courts function with respect, and that is not their role. The role of the courts is to decide whether the decision maker made the right decision or the wrong decision, the regular decision or the irregular decision. It's not for courts to hunt through the record and decide whether the discontinuation was objectively correct or not. And so with respect, the submission we make is that
Mr. Cochran,
sorry, Justice Jafta.
Would your argument differ if the policy we are concerned with here was not purportedly made under 29.2, but was made under 29.1b?
No, it would make no difference, Justice Jafta.
Isn't it then that the argument by UNISA to the effect that you don't have to look at what was before the decision maker, you have to look at the policy itself with reference to what the decision maker is placing before you now as factors which justify the policy itself? I understand your argument to say, but look at the specific language of 29.2. It commands the state when formulating a policy under section 29.2 to itself consider these factors. That argument I understand. Because as I listened to Mr. Chaskerson's argument, he equated the whole approach to a challenge to legislation passed by Parliament and said, no, you don't inquire into what was placed before the MPs when they passed that piece of legislation. You look at what the minister responsible for the administration of the legislation places before you in litigation as justifying the legislation impugned. So is there any difference, or your answer to it would be no, look at the specific language of 29.2?
With respect, Justice Chapter, we understood our learned friend in exactly the same way.
Yes.
He said this, he said, well, if it were Parliament, you wouldn't have regard to what served before them.
Yes.
But in this case, it's not Parliament. In this case, it was UNISA that made the decision.
Yes.
And we use this example in our heads of argument, but let me repeat it. And I don't for a minute mean to suggest this is what UNISA did. But UNISA could have flipped a coin. They could have said, you know what, it's a very difficult decision. It doesn't really matter what we decide, because either way, we'll be able to defend our policy in due course if we are taken before a court.
Yes.
So we'll just flip a coin. And if it's tails, Afrikaans gets discontinued. If it's heads, Afrikaans isn't discontinued. And assume tails come up, so Afrikaans is discontinued. And in due course, they come before you and say, we didn't go through the 29.2 discipline, but it doesn't matter, because let me now place before you a panoply of documents and let me try and stitch together a case that makes my decision objectively reasonable. With respect, Justice Jafta, that's not the way in which it works, and it's not the way in which 22.9 envisages that it will work, where it's the university making the decision. This is not legislation.
Okay.
And so with respect, we would say it does indeed make a difference.
Yes, thank you.
But Justice Jafta, what if I'm wrong? What if my learned friends persuades you that it is an objective decision? In other words, what if he persuades you that it is the same as Parliament, and so it doesn't matter that UNISA didn't go through the 29-2 discipline? He says, well, I can nevertheless stitch together a case that makes UNISA's decision objectively reasonable. And in that world, what can UNISA come up with? In other words, what can UNISA come up with to show that their decisions satisfy 29-2 objectively, even though they didn't walk down the 29-2 road? And we've come up with some possibilities, all of which are floated on the papers. Let me give you three possibilities. Number one, UNISA may say, my decision was objectively correct under 29-2 because the continuation of Afrikaans tuition would create racial polarization in the university, exactly the same as in the University of the Free State. In other words, they could say, my decision complies with 29-2 because it creates racial divisions in the classroom. Go away and read the UFS case. Well, with respect, they might say that, but they couldn't say that credibly because UNISA doesn't have real classrooms with real people in. And it doesn't have residences which may be divided on racial lines as happened in the University of the Free State. So precisely because UNISA is a distance learning education, that possibility, the UFS possibility, is simply not open to UNISA. What about the second possibility, objective justification? What if UNISA were to say, as they do through my learned friend this morning, they say, well, go away and read Afrikaans. That shows that it's justifiable to have regard to cost considerations in order to show that continuing tuition in Afrikaans was at odds with 29-2 because it would just be too expensive. Well, with respect, when one reads Afrikaans, one reads exactly what it is that the University of Stellenbosch did when they did the sums. And I'm going to give you the sums, give you the maths that was referred to by Justice Cameron. What the University of Stellenbosch showed I may be a little bit out. I'm sorry, I can't find it, but certainly my recollection is they did the maths, they worked out exactly how much the additional cost would be, and it was roughly 8,000 Rand, as I recall, on top of the 40,000 Rand that was being paid by an average student at the time. I may be slightly out, but I don't think I'm significantly out. The point is the University of the Stellenbosch did the sums, and they came before court and they put up the sums and they said that is not a cost that we can be expected to bear. And this court ultimately agreed with them. But with respect, when you go to this record, you will find no costing, you will find no maths, you will find no attempt to quantify what the additional cost is. Nothing. You will find one reference in one document in the Rule 53 record. It's all of 3 lines referring to the additional cost of printing study materials in Afrikaans. But it simply refers to it. It doesn't do the sums even in relation to the printing of materials. So with the greatest of respect to UNISA, if they want to run a Afrikaans case, the duty on them is to do the maths and to come before this court and to say, these are the costs, and they are not costs you can expect me to bear. But they simply haven't done that. So when my learned friend says this morning, well, it's not reasonable to expect UNISA to continue under the existing policy because it means that prohibits UNISA from providing tuition in other African languages, in other words, other than Afrikaans or English. That's exactly what UNISA hasn't shown this court. They must say to offer tuition in the other 9 languages or some of those 9 languages would cost so much and offering tuition in Afrikaans is costing so much, and they must then do that exercise. But what they can't do is come before you and say, I haven't done the maths, but nevertheless, I say that it would be unfair to expect me to continue teaching in Afrikaans because that will prohibit me in some way from offering tuition in other African languages. With respect, they must give you the detail, and there simply is no detail.
As I understood, the argument was based on the point of cross-subsidization. The argument being that resources were taken which could be spent in providing tuition in other languages to maintain the benefit that was there, which flows from our past. So I would like to hear you on that. I understand your argument basically is that show me the facts.
Show me the money, if I can put it that way.
Yes, yes. What do you say to their cross-subsidization argument that the resources are taken from the opportunity of providing education in other African languages to maintain the provision of tuition in Afrikaans?
Yes, thank you, Justice Jaffe. I'm grateful for the question. It is an important one. With respect, this is where Hoërskool Ermelo does the work. Our learned friends say, well, it doesn't seem correct that merely because Afrikaans was being offered at a certain stage in UNISA's history, that gives people getting tuition in Afrikaans some added advantage. I'm paraphrasing loosely what my learned friend argued. But with respect, that's the very thing that Hoërskool Ermelo does say. It says, if the right was being exercised at a particular point of time, it doesn't mean the right can't be taken away, but there must then be an appropriate justification for taking it away. And so with respect, that's why Afrikaans is in a different position to the other 9 African languages, because it was being offered at the time when the new language policy was introduced. So what would the appropriate justification be, Justice Jafster? Well, we can imagine a world where UNISA comes before you with chapter and verse and says, this is how much it is costing to give tuition in Afrikaans in those 300 modules that I refer to out of 2,300. And let me tell you how much it's going to cost to offer tuition in the other African languages I have in mind. And it then indicates that the one sum is making it impossible for them to offer tuition in the other 9 African languages. That's a world we can understand, but without the detail with respect, they can't simply say it must follow that because Afrikaans tuition is continuing, therefore I cannot provide tuition in the other languages. It simply doesn't follow in our respectful submission. It's not an axiomatic truth. It may be proved to be the case in due course, but then they must give you the maths. They must show the money. I don't mean real money, but they must show the sums in order to indicate that the cost calculation simply doesn't work.
Yes, thank you.
Mr. Cockerell, may I just take up that point further? Sorry. Just by the way, the judgment in UFS is a paragraph 31. Your sums weren't far off. It's an additional 8,100 Rand on top of the 40,000 Rand per year. That's what Stellenbosch University placed before this court. But I'd like to...
There's 100 Rand out, I think.
Yeah, 100 Rand out. I'd like to take this question further on Hoërskool Ermelo. And that's also the question I put to Mr. Jaskelson. But could I refer you to the judgment of Mogoeng CJ in Gelyke Kanse? I'd like to have your comment on what he says here. I'll just give you a moment to get there.
I have it, Justice Bridget.
It's from paragraph 48 onwards, where the learned Chief Justice quotes Moseneke DCJ in Ermelo. But the point that I want to get to is paragraph 50, where the learned Chief Justice says reasonableness within the context of section 29.2 demands that equity, practicability, and the critical need to undo the damage caused by racial discrimination also be the intrinsic features of the decision-making process relating to effective access to education in a language of choice. And he says later on, inequitable access and the unintended entrenchment or fueling of racial disharmony would thus be the appropriate justification for taking away or diminishing the already existing enjoyment of the right to be taught in one's mother tongue. That's the enjoyment of Afrikaans, read Afrikaans in this case. What is your comment on that passage? Because as I understand it, it means that you must look beyond cost considerations and also look at the need to undo the effects of racial discrimination where certain positions were entrenched, for example, the privilege of Afrikaans, which is a given factor. We must readily admit that Afrikaans did enjoy that privileged position.
I'm sorry, Justice Brigitte, I think you referred me to gelijke kansen, but were you reading from the UFS case?
Sorry, I was reading from UFS.
I was reading from UFS.
I'm so sorry.
No,
I have so many papers on my desk. I've referred you to the wrong one, paragraph 50 of UFS. That's the judgment of Mogoeng CJ. Cameron J was, of course, in gelijke kansen.
Yes,
sorry about that. Paragraph 50.
Yes, Justice Brigitte, again, I'm grateful for the question because I think it does in many ways capture the debate that we've had. May I respond in two ways? The first is in the UFS case, which is the one you have before you, Justice Brigitte, I would ask you to read the dissenting judgment of Justice Froneman. Obviously, I accept it's a dissent, but it does seem to me that part of the issue Justice Froneman was engaging with was in response to the very question that you've just asked me. And if you'll just bear with me, Justice Brigitte, I'm afraid my papers are also all over the place. If I can just find the paragraph I have in mind. Sorry, Justice Brigitte, just bear with me, please. Yes, it's paragraph 96 and paragraph 112 of the dissent. And in paragraph 96, what Justice Froneman says is, I'm not aware that this court has yet concluded that the mere exercise of a constitutionally protected language right can amount to unfair discrimination that would necessarily justify taking away that right. This is a novel and important issue. And then one goes to paragraph 112, where Justice Froneman poses the same question. This squarely raises a question of great constitutional and legal import. Can the exercise of one's constitutional right to choice of language in tertiary education result in discrimination proscribed by the Constitution? That is an objective legal question to be determined by a court. And then Justice Froneman goes on. And with respect, we draw your attention to that, Justice Brigitte, because although we do accept that was a dissent, in our respectful submission, there's nothing in the majority judgment in UFS to say that the answer to the question posed by Justice Froneman is yes. So UFS held, as a matter of fact, what was happening at the University of the Free State was that there was racial polarization in the classroom. But as I indicated in my opening 10-minute address, UFS, the majority judgment, expressly contemplates that there may be a world where there is not that racial polarity. And in that world, it would be permissible to continue tuition in Afrikaans. And the other point we would make in response to your question, Justice Brigitte, is the paragraph I read out, again in my opening address, from the judgment of the SCA in this case. I believe it's paragraph 45. Because in our respectful submission, that is the very issue that President Meyer was grappling with in that paragraph. It's paragraph 44. She says, to find otherwise would mean that the mere exercise of one's right to be taught in their mother language would be rendered unconstitutional when it has not been shown, and now I'm going to paraphrase, when it has not been shown that non-Afrikaans students would be deprived of learning or that maintaining it as a language of tuition would be unaffordable. I'm leaving out some words. So what the president was saying is, unless you have the factual basis to support that conclusion, it's not permissible to make the decision under 29.2. In other words, there may certainly be a factual basis to make that decision, but in the absence of the facts, it's not a competent decision, Justice Majid. With respect, that would be our answer to the question.
Mr. Cockrell, if I, excuse me, if I may put it differently, what you are contending is that there is nothing in the judgment of Mogoeng CJ, the majority judgment in UFS, that runs contrary to what was held in Hoërskool Ermelo about the abrogation of an existing right, which needs to be appropriately justified by the one who takes away that right. There's nothing into the contrary you submit.
There's nothing to the contrary. And may I say, in fairness, we agree with our literate Mr. Chaskelson that when it comes to what the appropriate justification is, we agree that this court in Gelyke Kanse has said that the appropriate justification is the section 29.2 standard. So with respect, we agree with him. This court has now said you don't get an added advantage because you were exercising an existing entitlement. It's the 29.2 test or no test. With respect, we agree.
And just lastly, I'm sorry to take you back there, but can you point me to the passages in Gelyke Kanse and UFS that you say support your contention that when you talk of an objective requirement as laid down by our courts in the jurisprudence of this court, when it comes to section 29.2, it does mean that the court must have regard to the factors which the decision maker, UNISA here, actually took into account. In other words, the UNISA must tell us what did you take into account, and this court must then consider them when it comes to the section 29.2 consideration. What are the passages in those two cases, please? I think I've missed them.
No, Justice Majid, with respect, there's nothing in UFS that I can point to which says that. And the closest I can come to in Gelyke Kanse is the passage that I think you put to my learned friend this morning in his argument. It's paragraph 42 of Gelyke Kanse.
Yes, I've got
You'll recall that's the passage where Justice Cameron says, I can't paraphrase it as eloquently as his language is, but he says, well, who must make the decision and why should I exercise deference towards the university? And he says, that's a good question. And he then goes on to say, but the university decision makers are the one at the coalface, so to speak. So one doesn't give them a free pass to make the decision, but one has regard to their decision in the first instance because they are the ones who know what is happening at the coalface. I've paraphrased it very loosely, Justice Majid, but it's paragraph 42.
Yes, thank you, Mr. Cockrell.
And that's the only paragraph I can refer to. Let me be absolutely clear. If you ask me, does UFS support what I've said? I can't give you a particular paragraph that supports it. All I can refer you to is Gelyke Kanse. And then the language of section 29.2, which I've already said, contains this clear textual marker. The state must have regard to it.
Mr. Cockrell, if my brother Majid is done, if I just understand your justification point, you're saying that the justification process must begin and be located in the whole consultation process before the decision or leading up to the decision to take a particular position on the language policy. And for that, there must be some reasons at play at that point, or some reasons must come into fruition as a result of the consultation process to justify the reasons taken at that point, long before it leaves the institution and processes through other forums. Is that the position?
Justice Pillay, I don't have to go as far as to say it must come out through a consultation process. That I don't need for my argument. All I do need for my argument is the decision maker, when it makes the decision, must go through the discipline of 29.2 and must apply its mind to A, B, C. It doesn't get a free pass. It may make the wrong decision. Court has the ability to second guess it and say, you made the wrong decision or you made an irregular decision. But I give two possibilities, Justice Pillay. What a decision maker can't do is to say, Number one, I didn't know about 29.2. I had no knowledge about it. Or number two, I flipped a coin. The decision maker must make the decision and must then subject the rationality of that decision to second guessing by a court. But a decision maker can't short circuit that. And so, Justice Pillay, in response to your question, do I need to go as far as consultation? I don't. But what I would say is this: when I go to the reasons of UNISA, you'll find them in the core bundle we put together, core bundle CB207. You'll find the heading, Reasons for the Currently Approved UNISA Language Policy. And you'll then find 3 pages of reasons given. And remarkably, in those 3 pages of reasons, you won't find a single reference to 29.2. You will find a reference to the Constitution on page CB207, but it refers to the other provisions of the Constitution, section 6. So here's the decision maker after the event justifying its decision. It refers to section 6 of the Constitution, but doesn't refer to 29.2. And that's as far as I have to go for my submission with respect.
Well, the question that occurs to me is that constitutions are supposed to be dialogical. Then how do you dialogue if you don't present reasons at the point of dialogue? That's the context in which I raised the question.
Yes. Now, may I make it clear, aspirationally, of course, one would want to have that process of consultation or that process of dialogue. That would be the aspiration. When I say I don't have to go that far, I don't need it for my legal argument, but obviously that would be the preferable outcome. Acting Deputy Chief Justice, I said, if we're in the world where my learned friend persuades you it's an objective test, it doesn't matter that UNISA didn't do the exercise. I've given you 2 possibilities. Number 1, the UFS reasoning, which I say doesn't apply. Number 2, costs. And I say that doesn't apply because they didn't give you the sums to show that they had done the cost calculation. The third argument, which is flirted with UNISA in parts of the papers, although I didn't hear it from my learned friend this morning, the third argument, objective argument, would go something like this. The argument would be, under the old policy, UNISA offered tuition in English and Afrikaans. It's inequitable to continue offering tuition in English and Afrikaans unless tuition is also offered in all other 11 official languages. And since it's not possible to offer tuition in all 11 languages, therefore, it's objectively justifiable to discontinue tuition in Afrikaans. That's the way the argument would go. And may I respond to that with 2 submissions? The first is, it's quite wrong to ask whether it's reasonably practicable to offer tuition in all 11 official languages in 2,300 modules. That's not the issue before this court. At best for UNISA, the question would be, is it reasonably practicable to offer particular modules in particular languages? So in other words, you don't ask, is it practicable reasonably to offer 2,300 modules in 11 languages? You ask, is it reasonably practicable to offer particular modules in particular languages where there's a demand for it? And that's the exercise UNISA simply hasn't done. And the second response we would make to that is, in engaging with that debate, it is relevant to have regard to the fact that some of the official languages are represented by more students than others on campus. My learned friend referred to the 2 documents that my client put up through Professor Pretorius, indicating the breakdown of the UNISA student population in terms of home language. I'm not going to go back to that, but there is another table I would draw your attention to, which is not limited to UNISA. It's in the minister's policy document. And the easiest place that I can find it is in the core bundle that Afriforum prepared. It's page CB20. Page CB20, this is the language policy of the Ministry of Education for Higher Education. And let me be clear, this is going back to 2002. I obviously accept it, it's well out of date. But what the table 1 is indicating is the percentage of total enrollments at all universities and technikons in South Africa, broken down in terms of the various languages. And I accept the stats wouldn't be exactly the same. The only point I do make is in engaging in this debate, is it reasonably practicable to offer particular modules to in particular languages? It's obviously relevant to have regard to what proportion of students would speak that particular language as their home language. And that's what the table is indicating. So Acting Deputy Chief Justice, where does all of that go on section 29.2? Let me try and summarize our submission. We say, with respect, UNISA's decision is an astonishing one because on their own version, they say they didn't regard themselves as being bound by 29.2, and there's nothing in the record to show that. For that reason alone, the SCA, with respect, correctly held that that was an error that went to the heart of UNISA's decision. When our learned friends say, well, it doesn't matter, it's objective, not subjective, we say that's wrong. But even if it is an objective question, in other words, it doesn't matter whether UNISA did the exercise or not, we say with respect that the documents in the record don't bring them home under section 29.2. That is the heart of our submission, and I can make my other submissions much more quickly. Let me deal very quickly with rationality. You'll know from our heads of argument that rationality is the second review ground. In response to the debate I've had with members of the court, if our learned friend were to persuade you that 29.2 is objective, then with respect, we would nevertheless say that UNISA's decision was irrational. Why? Because it didn't apply its mind to relevant considerations, the considerations being the ones listed in 29.2 of the Constitution. And the easiest way for me just to make that submission very briefly is to say this. We know that when Senate and Council made the decision, they didn't even have before them the statistics indicating how many Afrikaans modules were on offer. They didn't even have that before them. And so with respect, we would say that would render the decision irrational. But the real submission I want to make under the heading of irrationality is what this court calls procedural irrationality. And the jurisprudence of this court suggests sometimes the process is irrational, where there is no duty to consult. And Justice Pillay, this is why I said I didn't need this for my argument. There's no duty to consult, but it's nevertheless irrational not to engage with a particular group before you make a decision. And our submission, you'll know from the heads, is a very short one. We say, with respect, where UNISA is planning to introduce a new language policy that will lead to the discontinuation of tuition in Afrikaans, it's irrational not to engage with Afrikaans-speaking students in order to ask what they say about that. Let me be clear, I don't say UNISA had to agree with what the Afrikaans-speaking students say. I don't make that submission at all. What I do say is when you are about to make that decision, it's irrational not to at least engage with Afrikaans-speaking students to find out what they say about that. And it's common cause on the papers. UNISA never did that. They say it time and time.
Sorry, Mr. Cockrell, by that submission, are you suggesting that UNISA could not have achieved the purpose in 29.2 without consulting students? as I understand it, procedural irrationality relating to a hearing is limited to a situation where the purpose for which the power was granted cannot be achieved without that hearing. Now, in the context of 29.2, are you saying that if UNISA had not consulted the affected students, and here perhaps you'll deal with it later because Mr. Chaskalson said, no. Those who were already at UNISA continued to have their tuition in Afrikaans until they finished their studies. The issue is about prospective students. So I'm trying to see how this pre-decision hearing requirement becomes a component of procedural irrationality when one considers the objective that section 29.2 seeks to achieve.
Justice Jaffer, can I answer the question this way? If you go to the old language policy of UNISA, which you'll find in the core bundle we prepared at CB3. So CB3, this is the 2010 language policy, the one that was replaced. If you'd be so kind as to go to paragraph 4.2.7, this is what it says. Decisions by Council on recommendation of Senate regarding languages of tuition are preceded by and based on a formal investigation into the tuition needs, attitudes, and then the important words, and the preferences of students. So the old language policy envisaged that when you devise a language policy, you have regard to the attitudes and the preferences of students. And with respect, the submission we make is it's irrational not to at least engage with the students. And
also, your procedural irrationality point is not grounded in section 29.2. Is grounded elsewhere.
It's grounded in this.
Okay.
Justice Jaffer, that paragraph is in fact repeated in the, let me call it the new language policy, the one that forms the subject matter of these proceedings. If you go to CB9, 4.1.12, you'll find exactly the same wording. So even under their new policy, UNISA says, a language policy is guided by the attitudes and the preferences of students. And so with respect, the submission we make is when your old policy and your new policy says that, but you nevertheless say, I don't have to engage with students, that is procedurally irrational.
Now, how would that square up, assuming that UNISA for a moment had complied with section 29.2, but had not consulted students? How would that square up? Could we strike down a policy that complies with 29.2 on the basis of a requirement flowing from a policy?
Yes, with respect, Justice Jaffer, yes.
Now, what about the supremacy of the Constitution?
No, but with respect, Justice Jaffer, it would mean the challenge based on 29.2 is unsuccessful.
Yeah.
In the hypothetical debate we're having, you find that the challenge based on 29.2 doesn't have any legs. But that doesn't close the door on the possibility that the decision maker may nevertheless have acted in a procedurally irrational way in the manner in which they went about the decision. So with respect to the closing of the one.
I'm sorry to interrupt you. I'm trying to conceptually understand it because, as I understand, UNISA defends the policy on the basis of 29.2, aren't they?
Well, they've never put it up. That's sorry, Justice Jeffson, with respect, that's the idiosyncrasy of this case. UNISA's never relied on 29.2. When they are challenged by Afriforum for contravening 29.2, they offer various shields in response, but they've never put it up as a sword.
I understand. That's why I said, assuming that they were home and dry under 29.2. I'm trying to understand what would be the legal effect of a failure to meet procedural rationality that flows from a policy in that situation.
Yes, sorry, Justice Jeffson, I misunderstood you. I do understand you're posing a hypothetical question.
Yes.
I say again, it would be different if UNISA used 29.2 as a sword.
Yeah.
But since they don't, since it's just a shield to deflect the Afriforum challenge, it's conceivable. I don't for a minute suggest it would be preferable, but this court may say there's some difficult issues regarding 29.2, but procedural irrationality is a very easy way out. And so I don't make a decision regarding whether the 29.2 attack is good or bad,
Yes.
but I find that the decision was procedurally irrational and I set it aside on that basis.
Okay.
Again, please, I don't for a minute suggest it's preferable. All I say is, as a matter of logic, there's no reason why a court couldn't do that.
It's an added arrow to the argument.
I'm mixing up my swords and my shields and my arrows, but yes, it would be an additional weapon in the artillery, Justice Jeffson.
Thank you.
Thank you. And then, Justice Jeffson, thank you. You reminded me of the submission made by my learned friend in your question to me, and with respect, you're entirely correct. Our learned friend says, but this argument about procedural irrationality is absurd. That was his word, as I recall. He says it's absurd because it would lead to a logical conclusion that UNISA had to consult with every prospective Afrikaans-speaking student, and indeed, don't stop there, with every prospective student speaking any one of the 11, or every one of the 11 official languages. But with respect, the argument is wrong because it's based on a non sequitur. The argument goes, you only had to consult with Afrikaans-speaking students if you are going to take away their rights. Because you are not taking away their rights, therefore you didn't have to engage with them. I'm going to try and avoid the word consultation. Well, that's wrong for two reasons. Number one, it's true there's an enormous amount of confusion on the papers regarding how the phasing out of Afrikaans would work. But since many, at best for UNISA, they say it would be phased out by 2018. But if you're a part-time student studying in Afrikaans, you may well not have completed your Afrikaans tuition in 2018, in which case you would be affected by the phasing out. But even if that's not the case with respect, the argument about procedural irrationality is it irrational to make a decision without consulting with Afrikaans-speaking students? Not, is it irrational to make a decision without consulting with Afrikaans-speaking students who will not be affected by the decision? In other words, you consult with Afrikaans-speaking students, not just because they will be at UNISA for the next 2 years or 3 years, but because they will shed light on what other potential Afrikaans-speaking students in the future have to say. And that duty, with respect, doesn't fall away, even if the particular students you consult with would not be affected by the decision. And so, Acting Deputy Chief Justice, that then is our second point on irrationality. May I make the third point, legality? I'm going to make it in less than 2 minutes because it's a very short argument. It's about whether UNISA complied with its own rules. If one goes to the Senate rules say that an item on the agenda must be made available to members of Senate. As I recall, it was 5 days in advance of the meeting. Yes, 5 working days before the meeting. Common cause, that didn't happen in this case. The members of Senate were sent the documents by email at 6:30 the evening before the meeting. So at 6:30 on the evening before the meeting was held, that's when they get the documents. There's no compliance with Rule 11.1 of the Senate rules. No debate about that. it is correct that the Senate rules do contemplate that it's possible to depart from the rules, but that is done by Rule 13.1. I'm sorry, I've got the wrong rule. The departure is dealt with by Rule 13.6, which says it can be remedied by a unanimous resolution that is properly recorded. So a unanimous resolution of Senate properly recorded could have overridden the fact that the documents were not sent 5 working days before. But with respect, that doesn't get UNISA out of the woods, because number one, there was no resolution properly recorded. There was no resolution at all. And number two, it wouldn't have been unanimous because we know at least one person, Professor Bjornman, would not have approved the vote had it been put to the vote. So with respect, the submission is a very short one. The Senate rules imposed restrictions on how Senate went about its business. There was not compliance with that rule, and there was no unanimous resolution to depart from that. And so for that reason, the Senate resolution was invalid, and that would have a domino effect on the Council resolution for the reasons set out in our heads. But I don't want to dwell on that, Acting Deputy Chief Justice. That is our third submission, if the court finds it necessary to get there. I would like to make some submissions about remedy, though, and this is the fourth part of my address. So the hypothetical assumption I make is if the court were with UNISA, if the court were with Afriforum on the merits, in other words, were minded to uphold the SCA judgment on the merits, the question then becomes, did the SCA give the correct remedy? And should this court interfere with the remedy, even if it were with Afriforum on the merits? And we understand our learned friends to make two arguments in that regard. The first argument is they say, well, the SCA goes too far because it doesn't perpetuate the discontinuation of Afrikaans policy. Acting Deputy Justice, with respect, we've set out in our heads why, if you read the judgment of the SCA as a whole, it's evident that the SCA was not overriding that discontinuation of Afrikaans policy because it referred to it time and time again. And so in our respectful submission, the order of the SCA, if it were to be retained, would perpetuate the policy. But with respect, if there's any debate about it, this court could simply make it clear. In other words, if our learned friends say it's not clear that the SCA order is meant to perpetuate the policy, well, with respect, this court could simply make it clear. But certainly on our reading of the SCA order, it was not meant to override the policy. It was meant to create a world where the policy would still be implemented, and so Afrikaans could be discontinued if, during the time when the SCA order is being implemented, the demand for Afrikaans in a particular model were to drop below the threshold. The second submission our learned friends make is about suspension, and I need to spend a little bit of time on this. They say, well, this is a textbook example of an order that ought to have been suspended in order to give UNISA time to get its house in order. Let me start with this, and with respect, it's an important question for this court to grapple with. Why does UNISA want suspension? What does it want to do during the period of suspension? And to answer that question, I'm going to ask you please to go to the heads of argument of UNISA, because you'll find the argument in paragraph 7. So it's UNISA's heads of argument, paragraph 7. This is what UNISA tells the court. It says UNISA asks that any order of invalidity should be suspended until the start of the 2023 academic year, so that UNISA can be given time either, I would emphasize, either to put in place the personnel and systems required to reinstate Afrikaans language learning after a hiatus, which will be at least 5 years, or to design and implement a new constitutionally compliant language policy. So UNISA is hedging its bets. Why do I want suspension? Well, they say either we will put in place the systems to retain Afrikaans, or we'll enact a new language policy which abrogates the continuation of tuition in Afrikaans. Now, with respect, the problem for UNISA is once it hedges its bets in that way, it's got to tell this court how much time it wants, and it's got to explain why it wants so much time. And the time it wants may depend on whether it wants to give effect to the order or whether it wants to enact a new policy. And I say that because the jurisprudence of this court for more than 20 years has been that when you ask for suspension, you must put up the case for how much time you need, and you must create a factual basis for that. And I'm going to give you the authority. It's not referred to in our heads. The authority is State versus Ntuli, 1997, volume 3 of the South African Law Reports 772. It's a judgment of this court, and the relevant paragraph is paragraph 41. And if I can paraphrase what Chief Justice Chairperson said in that case, he said, no longer will they simply give litigants a free pass under suspension. This court will now expect litigants who ask for suspension to explain how much time they need and why. So here's the problem for UNISA. It asks for suspension. It's got to tell you how much time it needs and why. Well, in the affidavit of UNISA, the paragraph I learned and Mr. Chairperson referred you to, they did ask for suspension, but they asked for suspension for 9 months. That's the time they asked for, and they made out no case for why they needed 9 months. They didn't comply with Ntuli. They didn't explain why they needed 9 months. So when you apply the Ntuli test and ask, has a case been made out for suspension and for the period asked for? With respect, there's simply nothing on the record to show why 9 months would have been appropriate. But now it's even worse. Now they say they want until the commencement of the academic year in 2023.
Mr. Cockerell, I take the point about hedging their bets, but in the heads from paragraph 34 onwards, they explain why they need until the commencement of the academic year of 2023. What are we to make of that?
No, Justice Bridget, with respect, you're correct, but why I drew attention to paragraph 7 is it's correct. In that paragraph 34, it's all about how long it will take to put the systems in place. But paragraph 7 has made it clear they may not do that at all. They may just implement a new language policy. So when I say they can't hedge their bets, with respect, they must make it clear whether they're going down the one road or the other road. What they say is, I may go down either road, but let me tell you how much time I need if I go down the right road. But they make out no case for how much time they need if they're going to go down the left-hand road, with respect. But Justice Brigitte, in response to your question, you say, well, if we take them at their word in paragraph 34, what do we make of what is contained in there? And with respect, there is simply no factual basis on the record for what they say in paragraph 34 of their heads. First point to make, 34.1, they say some of the modules that were on offer in Afrikaans may have been entirely discontinued. Well, if that were the case, they should have put up the evidence. And the same requires to 34.2 and 34.3. And it loops back to the question that I think you asked me, Justice Brigitte, at the commencement of my address. What do we make of the fact that they didn't apply to place evidence on record regarding what has happened since 2016? And the answer is it's a problem of UNISA's making with respect. When they say a lot of water has flowed under the bridge, which Dr. Lindgren said this morning, well, that may well be the case, but then the job is for UNISA to apply to lead evidence before this court to explain what water has flowed under the bridge and to explain how much time they need. And since they haven't done that with respect, there is no probative force to be attached to what is now said in paragraph 34 of their heads of argument.
Mr. Cockrell, my brother Jafta raised an interesting aspect, the apparent incongruity between the orders in 2B and 2C, or 2A and 2B of the SCA order.
Yeah.
The one that says the resolutions are set aside, and if you set aside the resolutions, of course, there's no policy, there's no new policy.
Yeah.
So how do you excise the bad part of the policy if there's no policy that exists, no extant policy?
Yes, thank you. I'm grateful for the question because I had meant to address that. Let me start by saying this. In its supplementary founding affidavit, Afriforum said they only challenged the new language policy to the extent that Afrikaans was discontinued. I'm going to give you the reference. It's page 325, para 208. Now, in that same paragraph, they said they would amend their notice of motion to make that clear, and the amendment wasn't done. So just to be clear, Afriforum says when they supplement, our only objection to the policy, the new policy, is to the extent that Afrikaans is discontinued, and we'll amend our notice of motion. But the amendment isn't brought through. But with respect, when the SCA gives the order, Justice Majid, in paragraph 2B of their order, they get it entirely correct because they correctly understood the Afriforum case. So 2B sets aside the new language policy. It's set aside to the extent that Afrikaans has been removed as a language of learning and tuition. Entirely consistent with the Afriforum case, albeit that they hadn't reflected in the notice of motion. The disconnect that Justice Jafta refers to is, but if you go to 2A, they set aside the resolutions in their entirety. We understood, my learned friend Mr. Chaskelson, very fairly to make the concession today that it may be possible to read 2A as only applying to the resolutions to approve the new policy to the extent that Afrikaans has been removed as a language of learning and tuition. But if that isn't clear, I have the instruction from our client. My client would have no objection if this court were to amend 2A so as to make it clear. In other words, the resolution would be set aside only to the extent that Afrikaans has been removed as a language of learning and tuition. It would be the same wording in 2B, which would then be carried through to 2A, should the court consider that necessary.
What should we make of then, Mr. Cockrell, of reliance on non-compliance with the Senate rules?
Yes.
Because I understand that cuts across everything. It's not limited to the portion that referred to Afrikaans, or should we, you're not persisting on that?
Justice Jafta, you're entirely correct. If the failure to comply with the Senate policy point were good, in law, it would knock out the whole of the resolution. You're entirely correct as a matter of law. But I say again, it's for my client to decide what relief it wants. And the instruction I have is that they would only want the resolution to be set aside to the extent that Afrikaans is discontinued. For the rest, they have no quarrel. I do understand the logical inconsistency, Justice Jafta. All I can say is as a matter of form, that's all that all that Afriforum would be asking for.
Yes, the difficulty that puts us in is that if we were for a moment to say the non-compliance with the rules point is a good point, and our judgment should be based on that, it would be illogical for us to say, but although the rules were not complied with, which would vitiate the whole policy, we're going to sever only the portion relating to Afrikaans from the policy. It doesn't seem to be legally correct.
it's not correct as a matter of logic. You're entirely correct, Justice Jafta. As a matter of logic, the whole thing would fall. But in this hypothetical world, the successful litigant before you would be saying that's all it asked for. So in other words, when one fairly reads the Afriforum papers, their complaint is always about the aspect of the new language policy that discontinued tuition in Afrikaans. And that is the path that they want to go. And so the litigant before you, in this hypothetical world, the successful litigant, would be saying that's the only component it wants to go. So
well, speaking for myself, I find it a bit difficult to appreciate. I think you're right. It is up to Afriforum to decide which case it wants to prosecute, based on what. Once you get into the lane that you have chosen, and that lane takes you further than what you wanted, I'm not quite sure that the court can say, well, despite the fact that we say there has not been compliance with the rules of the Senate, which affects the whole policy, we're going to carve out only the objectionable part identified by Afriforum. That's my difficulty. No. It's either Afriforum says, forget about the non-compliance with the rules. This is what we are pursuing. We want you to limit yourself only to the issue of the part that refers to Afrikaans. And then we deal with the matter on that basis.
No, I understand the question, Justice Jafta. Let me see if we can break it down. If the 29.2 point were to be upheld,
yes,
would the same difficulty apply? Because of course the SCA didn't deal with the failure to comply with the Senate rules point. So from the SCA's perspective, what was objectionable was the discontinuation of tuition in Afrikaans, and yet 2A sets aside the whole of the resolution.
Yes.
So, and I understood by Mr. Chairperson to agree that 2A could be qualified so as only to refer to the discontinuation of Afrikaans if the 29.2 point were good. That's
no. If the 29.2 point is good, the problem would not arise.
Okay.
Because then we would not have to refer to the non-compliance with the rules.
Yes.
But I'm just because we won't have you before us then when we decide. If the only point that we find to be good is the non-compliance with the rules, what do we make of the remedy then?
Yes, no, I do understand. So you're saying once I'm in the lane regarding failure to comply with the Senate rules, you're saying as a matter of logic, the whole thing must fall. And so you're asking me, does my client want to stay in that lane or not?
Yes. Yes.
Just I'm sitting in Cape Town, my attorney and my junior and my client, they're all in Pretoria or Joburg. Can I get an instruction from them on that?
Okay.
I don't want to detain my learned friend. Perhaps I can convey the instruction at the end of his reply, unless that's going to prejudice him.
Okay, no, that's fine.
Mr. Cockrell, the legality point also raises the other difficulty, and that is that from what I understood you just say, that the approach to changing the policy in relation to Afrikaans, UNISA went about it entirely the wrong way. And that's not only about how the resolution came about, but what went on before that. What I understood you to say that what its language requirements, specifically in relation to Afrikaans, was per module, should have been investigated thoroughly and that put on the table. So that would precede any policy, that would precede the resolution. And from that point of view, shouldn't UNISA be told to go back to the drawing board and fix, at least in relation to Afrikaans, if not anything else?
Yes, Justice Pillay, but I'm sorry, I'm probably being obtuse. As I understand it, the debate is about whether 2A of the order could be limited so as to include the words to the extent that Afrikaans has been removed. And is the proposition you're putting to me that if the review, not the review ground, if the ground for challenge is good, then those words couldn't be written into 2A. Is that the concern?
No, the question my question is, if we're going to say or take the route that that the resolution by Senate was improperly taken, then everything that preceded the resolution improperly taken would be fraught with illegality. But more specifically, from a practical point of view, you said that what UNISA should have done from the outset in terms of process and its arriving at this policy should have been a careful analysis practically of what its language needs were per module for Afrikaans. And that was not done. And therefore the resolution on Afrikaans, besides being illegal for the reasons you've advanced, was improper for that reason. And so I'm adding to the reasons for this inquiry whether correcting the order is going to be enough, or whether we're saying something else.
Yes, Justice Pillay, but if I can use Justice Jafta's analogy, in that particular lane, I don't think there's a severability problem. Let me put it more correctly. In our respectful submission, there is no severability problem in that lane. There is a severability problem, Justice Jafta, as a matter of logic, in the failure to comply with the Senate rule lane. And that's what I need to take an instruction on.
Okay, thank you.
Thank you.
Mr. Cockrell, I still have a concern with the order, and if I could just conclude my part of the questioning on your heads. When you discuss a remedy about the status quo ante at page 45 and forward and onwards of your heads, you say that paragraph 109, the SCA judgment refers to the guidelines, and then you say in the next page, the SCA order does not mean that UNISA is required to reinstate Afrikaans modules that have already been discontinued. Well, the problem is not with the reasoning, because an appeal never lies against the reasoning, lies against an order. My difficulty is with the order. The order at paragraph 2C, Roman 2 and 3 of the SCA. Now, first, it requires in Roman 1 that UNISA must publish a full list of all the modules that were on offer in 2016 April. And then in 2, offering all prospective students for the next academic year admission in such modules as presented on first year level. And then 3 deals with those students who had been pursuing tuition in Afrikaans and were then compelled to switch to English because of this new language policy. That order does not make provision for the guidelines for discontinuation to be applied. And therefore, UNISA makes the submission that this is more than restoring the status quo, and it actually goes further than that. It disallows UNISA to apply the guidelines. And that bothers me tremendously. Surely, if we do, it's a question of unscrambling the egg. How do you do that without allowing the guidelines to apply for discontinuation? You have, for example, 5 students who want to pursue a particular course in some or other subject, in some other module. How do you order UNISA to offer all prospective students that admission? That's my difficulty.
Justice Brigitte, with respect, of course, you're correct. The appeal lies against the order, not against the reasons. But it's certainly competent to read the reasons in order to understand what the order says. And the only point we make in our heads of argument is because the SCA was clearly alive to the discontinuation policy, in our submission, they were not intending to override that. When one goes to Roman 1 and 2, in our respectful submission, what that means is if tuition was being offered in Afrikaans in a particular module on the 28th of April 2016, it must now be offered on that basis on a first year level. The debate, as we understand it, is Well, what happens in the second and the third year if the demand for Afrikaans drops below 15 students? Can the module be discontinued? And we would say with respect, yes, it is, because the discontinuation policy would continue to apply. But Justice Majidi
Well,
said,
sorry to interrupt you. Would any harm be done, and would your client be averse to that being clarified, to say that the discontinuation policy remains extant if we retain those parts of the order as it stands?
That's Majid, I would have thought the answer is no, but I am going to ask you whether I can take an instruction in that regard, if you don't mind, just so that I don't talk out of turn. But I would have thought the answer is no, because as you'll know from our submissions, that is our reading of the order.
Yeah.
But I will get an instruction on that, and I'd also get an instruction, if I may, in relation to Justice Jafta's logical point, which is, if I'm in lane 3 about failure to comply with the Senate rules, what does that mean for the order?
Thank you, Mr. Cochrane.
Acting Deputy Chief Justice, I need to come back with an instruction on those two issues.
Yes.
As I say, there's a bit of a challenge because I'm not with my team, but I can either do it at the conclusion of my learned friend's reply, or I can do so now, if it would prejudice him not to be able to respond to whatever my instruction is.
Yes, Mr. Cochrane. Mr. Chairperson.
Acting Deputy Chief Justice, I don't think I'll be unduly prejudiced. I mean, in the unlikely event that something is said that calls for a response from me, I'll ask leave to respond to it then.
Yes.
But I don't see that as likely, and I'd rather not waste the time of the court.
Thank you. That raises the issue then that Mr. Cochrane, you may take instructions and respond after Mr. Chairperson has concluded his reply.
I'm grateful to my learned friend. I'll do that. Acting Deputy Chief Justice, those then are our submissions, unless the court has any further questions. For all of the reasons I've given, we would ask that either that leave to appeal be refused, or if leave to appeal is given, that the appeal be dismissed. In either case, we ask for the costs, including the cost of 2 counsel. If the court is against us, if UNISA succeeds, may I say, as we understand it, UNISA no longer asks for costs. They did ask for costs against Afriforum in the previous hearings, but as I understand it, they no longer ask for costs. So if UNISA were to be successful, there would be no cost order against my client. If my client were to be successful, I don't understand there to be any debate about the fact that cost would follow the cause. But subject only to the 2 items of instruction that I owe you a response on. Those are our submissions.
Thank you, Mr. Cochrane. Mr. Chairperson.
Thank you, Acting Deputy Chief Justice. There are 4 points that I want to respond to. Briefly, to respond to my learned friend's submissions in relation to the cost of sustaining Afrikaans language tuition. Then to address the submissions he made on what an objective test is, and what was required of the UNISA. Then to look factually at what UNISA did have regard to in the light of my learned friend's submission on the nature of an objective test. And finally, briefly to touch on the implications for remedy of my learned friend's argument. So first point, very simply on costs. The whole debate on costs in the papers takes place within a framework in which it is common cause that multilingualism is expensive. That's Afriforum's own words, who say there is a cost attached to mother tongue education and multilingualism which cannot be denied. That's volume 3, page 518 or 528, according to handwritten and bold, paragraph 36.6. So what that means is that if you offer Afrikaans language tuition, but no other home language tuition, what you are doing is you are subsidizing Afrikaans language learners at the expense of learners of other home languages. That's a simple fact that is common cause on the papers. So if this court forces UNISA to go back and reinstate the 2010 policy in relation to Afrikaans language of learning, what UNISA is, what this court will be doing is forcing UNISA to subsidize Afrikaans language learners at the expense of others. That is the framework within which this debate has to take place, and that's common cause. In relation to the objective test and and what 29.2, how to apply 29.2, my learned friends urged this court to recognize that the test was an objective test. He readily conceded that 29.2, the decisions under 29.2 are not administrative action. But he then proceeded to urge this court to apply a test which, as far as I could work out, was completely indistinguishable from a Padgett test, both in terms of substance and in terms of process. I couldn't see the distinction anywhere. And with respect, he's wrong on that front. If the test is an objective test and it's not administrative action, then the test is much narrower. Firstly, it's objective. It doesn't have regard to what's served before the relevant decision maker. It has regard to what facts are brought to the court to justify the decision. So the issue is not, did UNISA look at this or look at that? Did UNISA understand its legal obligation correctly? It's, is this decision objectively consistent with Section 29.2? Likewise, in relation to process, one can't say, well, no, this is process rationality in Section 29.2, and so we'll just simply apply a version of the Padgett test. The only test that could be relevant to procedural irrationality is if it is not possible to give effect to Section 29.2 without consulting either current or prospective Afrikaans students. I've made my submissions on why that is not the case. But let's, for a minute, step back and look at the implications of if one accepts my learned friend's characterization of the test, and if this court were to conclude it must have regard to what served before UNISA and what UNISA had regard to. And I want to make the simple submission that even if UNISA did not self-consciously apply itself to giving effect to Section 29.2, because it didn't, and we'll explain why it didn't because the leading authority at the time, decision of the SCA, which no other court seemed to have paid any attention to, said that Section 29.2 was not binding on individual educational institutions. So UNISA was following the law at the time. It didn't apply itself self-consciously to giving effect to Section 29.2. But what it did do is it had regard to considerations of equity, practicality, and the need for redress. That's what this whole debate is about. So it can't be penalized for not mentioning the magic words Section 29.2, particularly not in the context when the leading authority at the time said it didn't have to. And that leading authority was Minister of Education, Western Cape, versus governing body Micro, 2006, volume 1 essay, page 1 SCA, was binding on, was the highest authority to consider this specific question at paragraph 31. It said specifically that the right of the Section 29.2 obligation is carried by the state, not by individual educational institutions. We submit that this has particular implications for remedy. If the issue now becomes what UNISA subjectively considered, and the decision is struck down because the law, as UNISA understood it, has now changed, and the obligation is one that is carried by UNISA directly, and UNISA didn't understand that at the time, then UNISA must be...
I'm sorry, Mr. Chairperson, to interrupt you. If the SCA had incorrectly interpreted section 29.2. Does that mean that the law was different? Aren't we looking at what section 29.2 always meant? Whether some court had interpreted it in a manner that is incorrect, yes, it may explain or justify why a particular process was followed by a litigant. But does it really mean that the law has changed?
No, the law is well, the law has now been stated in a way that is inconsistent with the MICRA judgment. That's clear. And UNISA's reliance on the MICRA judgment has now been shown not to be consistent with the correct understanding of section 29.2. I'm not disputing that. I'm not suggesting that UNISA didn't carry the 29.2 obligation. I'm making two submissions. The one is at the level of fact. UNISA, even though it did not understand that it carried the 29.2 obligation, had regard to the very considerations that the 29.2 obligation places on it.
Now, I understand that argument. I think it's a separate argument. I was responding to the submission that UNISA acted in terms of the law as it was then. My query is, okay, all right.
But it has huge implications for remedies, my submission. Because now UNISA now understands the law as it is. And it now understands that it must make the investigations that are being called on, that are being demanded of it. And that if it wants to change its language policy, it has to conduct those investigations. It has to produce the fruits of those investigations to Senate and Council. And it must act on the basis of those investigations. But for the purposes of remedy, what that means is that UNISA ought to be given the opportunity to conduct the necessary investigations. And once it has done so, it may well reach a conclusion that it is not economically feasible to revert to the 2016 policy, or that a variant of the 2016 policy should be put in place. And it should be given that opportunity before it is forced to resurrect the 2010 policy at a potentially substantial wasted cost to the institution. So the university should be given that opportunity. And that's why the suspension is, in our submission, the clearly appropriate remedy if this court is against UNISA on the merits. Now, my learned friend says that because UNISA won't pin its colors to the mast, it can't ask for a suspension. But with respect, he's entirely wrong in that regard. And I would like to take this court to the reasoning at paragraphs 39 to 41 of our heads, which makes it quite clear why UNISA cannot be called upon to pin its colors to the mast now. Because the two processes, or the alternate decisions, are not separable from one another. And at 39 of our heads, we point out that if the status quo of April 2016 is now to be reinstated, UNISA is going to have to design a plan to reinstitute Afrikaans language and learning in all modules where it was offered in 2016, and be in a position to do that at the start of the next academic year. What this means is UNISA is going to have to investigate the personnel and IT infrastructure changes that will be required. It's going to have to investigate the costs of implementing these personnel and IT changes, together with other costs like translation and printing. It's going to have to rebudget to take account of those costs. And it's also going to have to do that in today's financial climate, not in 2016, and today's financial climate comes on the back of a period of sustained underfunding of tertiary educations by the state. So If after it's done that whole process, it concludes that it's reasonably practicable to reinstitute the 2010 language policy insofar as it relates to Afrikaans, it's going to have to implement all of these changes, recruit new personnel, make the IT changes, and do that in time for the start of the academic year. But until it's rebudgeted and considered the judgment of an adverse judgment of this court, it can't work out whether it is or isn't reasonably practicable to reinstitute the 2010 language policy. And if after a judgment of this court, it has rebudgeted and done all the necessary changes and it realizes it can't do this reasonably practicably, then it's going to have to redesign a new constitutionally compliant language policy. The either or is not hedging bets. The either or is a simple reality. It has to investigate these issues in the light of a judgment which explains what are and aren't its obligations, and decide whether it is practicable. It can only decide on the practicability if the investigations have been complete. If it decides it's practicable, then its obligation is to resurrect the 2016 status quo. But if it concludes that it's not practicable, then at that point it's got to put in place something else. And all of this takes time, which is why we say on the heads that UNISA would require at least 6 months from a judgment of this court, or 6 months between an adverse judgment of this court and the start of the next academic year to do all of this. And that's why we ask for the suspension that we do. If this court is capable of handing down a judgment before the end of June, then the suspension, if the judgment is adverse to UNISA, can be to the start of the 2022 academic year. But if that's not the case, then the suspension has to be to the start of the 2023 academic year. One cannot will away the realities of having to reorganize the affairs of an institution after a period of 7 years since, or 6 years since it last operated in a particular fashion.
I suppose, Mr. Chaskalson, a different way of putting it is that once we suspend the invalidity, if we are with you, it's not for us to say what you should do during that period of suspension. I mean, then we would be intruding into the terrain of executive action. Everybody agrees that this is executive action. We cannot prescribe to UNISA, to its council and its senate and other structures, whether it should revisit the policy and vary the policy, or whether it should simply implement the old policy as it was. It's not for us to say that.
Indeed, Justice Majid. And our primary principled objection to the SCA order is the SCA was prescriptive in a very, very specific way. So we would ask for a period of suspension, but we would emphasize that the period of suspension must be one that is sufficient to allow a satisfactory process to take place before the start of the next academic year. Of course, our primary submission, Justices, is that the appeal should be upheld on the merits, and we don't back away from that argument. But on the issue of remedy, if this court's against us, we would emphasize that a suspension would be required to allow UNISA to decide where to go next, and to do so in a financially responsible fashion. Those then are our replying submissions, Justices. Unless there are any specific other issues that you would like me to respond on, those are my submissions in all.
Thank you, Mr. Chaskalson. Mr. Cockrell, have you been able to take instructions from your clients?
I have, and I'm grateful for the opportunity. I owe you an instruction on two matters. The first is Justice Majid's question to me was, in order to remove any uncertainty, does my client have an objection if the order of the SCA were to be amended so as to make it clear that the discontinuation of Afrikaans policy will apply? And my client has no objection to that, Justice Majid. So in other words, the court, if it considers appropriate, would then write in the appropriate words so as to make it clear that the continued offering of Afrikaans tuition would be subject to the discontinuation of Afrikaans policy. That's the first question. The second question is in response to Justice Jafta. And let me just check that I'm responding to the correct question. So Justice Jafta says, if I'm in lane 3, in other words, the Senate failed to comply with its own rules. If I'm in that lane, and if the court were to agree with that submission, then as a matter of logic, surely the whole of the resolution should be set aside and not just a severable part of the resolution. And let me respond as follows. The first is my client doesn't abandon that lane. So in other words, my client is not prepared to give up that argument. We continue to persist with the argument that there was failure to comply with the Senate rules. If you were to find against us on that, the point becomes academic. If you were to find for us in that regard, we have two submissions, Justice Jafta. The first is under section 1721, under subsection 172 sub 1 of the Constitution. Our submission would be the court must then declare that the Senate resolution was invalid. Must, it has no discretion. But it does have a discretion under section 1721B to make any other order that is just and equitable. So we would respectfully submit the court should then declare that the Senate resolution was invalid, but should then make an order that has the effect of only setting aside the Senate resolution to the extent that Afrikaans was discontinued. So the declaration would be correct as a matter of logic, the proposition you put to me, but to the extent that the order has any teeth, it would only apply to the part of the Senate resolution that discontinues Afrikaans. But Justice Jafta, if you're against us on that, and if the court were to form the view that it simply can't be done under section 172 sub 1, then my client would ask that the whole of the Senate resolution be set aside. In other words, the proposition would then continue.
I would assume that the remedial powers in section 172 do not include granting illogical remedies.
Mr. Jafta, as I say that is a submission we make, but if the court were to be of the view it's not just and equal to grant an illogical remedy, then my client asks for the logical remedy, which is set aside the whole of the resolution.
Thank you.
And then, Acting Deputy Chief Justice, if I can just make one final response with your leave. Justice Majid asked me where in Gelyke Kanse or in UFS has this court indicated that it's the decision maker that must apply its mind to section 29.2. I gave him the answer under Gelyke Kanse. I said there was nothing in UFS. With your leave, my learned junior draws my attention to paragraph 50 of UFS. And I'm not going to make submissions in that regard, but I would simply draw the court's attention to paragraph 50, which may also shed some light on the question Justice Majid posed to me. And thank you, Acting Deputy Chief Justice. Thank you for the indulgence.
Mr. Chairperson, would you like to be given an opportunity to make a reply in regard to Mr. Cockrell's submissions now?
Acting Deputy Chief Justice, very briefly, because I didn't respond to the Senate rules point. Our brief submission in that regard is that the Senate rules do not have the status of delegated legislation, the non-compliance with which will invalidate acts. They are instruments of the sort of a domestic rules of a domestic tribunal, and they accordingly are not rules relevant to the legality principle. The issue is traversed in the judgment of His Lordship Mr. Justice Sutherland in the context of the interim relief application in this case, and we stand by the conclusion of the learned judge in that regard.
Thank you, Mr. Chairperson. Judgment is reserved and the court is adjourned.
As the court pleases.
Today's proceedings
As the court pleases.
have concluded. The host will now take